so far. And I tried to do the case on it is taken a short term. Another case is
Let's appeal. Application for bail belongs custody since last 10 years.
Please give it.
consolidation.
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 Consolidation matter ଆମର ଅଛି ଅଛି put down the telephone. Please give it.
Allotment of a Japan legal land. Second.
No. These matter over the on the No, on assignment change.
Let's may be permitted to make a mention out of the list.
Yeah.
Well, it's item number 29.
And for the petitioner, my learned friend is appearing to the opposite party. We kept on some other day already.
Well, I need to file an affidavit along with some documents.
Item number
29.
29.
Jeevan Kumar Man.
Right.
So you are for the opposite party.
I am for the petitioner.
I am for opposite party.
You want to file some documents or what?
There was a direction to bring on record certain documents relating to the matter. This matter arises out of the GRF and ombudsman. So certain documents were to be brought on record. I need a week's time if your lordship pleases. I'll bring it on record.
50% of the claim amount we had deposited and interim stay was
And
granted.
by the order dated 23/2025, there is a direction that no coercive action shall be taken against the petitioner subject to deposit of rupees 10 lakhs by him before TPCODL within a period of 7 days from today.
We had deposited.
It is made clear that failure to deposit the amount directed above this, they have already deposited.
We have already.
You are for the petitioner, no?
It is.
Yes, deposit has already been made.
Minus interim, that particular order is there.
The learned counsel for the petitioner. Your good name is Mr.
Ashutosh Man.
Ashutosh Mahanti submits that as per the order dated 23/2025, the petitioner has deposited a sum of rupees 10 lakhs before the opposite party. Stop. The learned counsel for the opposite party doesn't dispute the same. Stop. The learned counsel for the opposite party seeks for an adjournment to file certain documents. Put up this matter. The learned counsel for the petitioner has no objection. List this matter in the second week of July 2025. Interim order dated 23/2025, passed in IN number 467 of 2025 shall continue till next date. Yes.
Bless me.
Item 10, man.
Yes, just.
This letter no time to put up in 26.
Wait. Tikke ରୁହନ୍ତୁ. What is the item?
Item 10.
What do you want, Mr. Jarling?
My lord, it will be taken up in 26. I will file affidavit, which are the application. And then that is.
Now you are supposed to get the instruction, but you want to deposit 1,20,000.
That will be coming, my lord.
That instruction is awaited. So when do you want it? Next week?
Any data of this.
All right, let go. Mr. Jalil and counsel, item number 10, submits that as per order dated 17/6/2025, is yet to obtain instruction regarding the readiness of the petitioner to deposit a sum of rupees 1,20,00,000 lakh before the opposite party bank. Stop. Who is appearing for the bank? Nobody is appearing. All right. Put up this matter in the week commencing from So let it come on 30th, or you want in commencing from 7th July?
Yes.
And let's keep it on 7th July for them. 7th July 2025. Next. All the matters serially.
Weekly list item number 1.
Mr. Niyamati,
Procedural. Well, since because of the delay of disposing section 14 application by the London District Magistrate, we have filed this application for early disposal. When the case is pending, well, they have passed an order. Madam, can we see the last order of this?
last order, that is the only order part. That is order number 1,
Well,
dated 15/1/25.
well, in that,
You have got a copy of that order with you.
well, that I have filed the additional affidavit.
Just a minute. Mr. Niyamati, London Council for the petition submitted that on 18/12/24 an order has been passed by opposite party number 1 district magistrate, which mentions that another case is pending in the court of London District of Orissa relating to this matter and kept the application under section of 1 for disposal after the disposal of the said case by the presiding officer DRT Kata. The said order passed by the opposing party number is taken under clause. In view of the subsequent developments, the land counsel for the petition submitted that he wants to bring this order with an affidavit and also file an application for amendment of the petition. So what is that?
Two things are there. One, my lords, because he has no authentication power, my lords. DN has no, DN has no power for identification of any dispute, my lords. One. Second is, my lord, just we have given an affidavit at the time of filing. There is a
No, suppose you see, suppose in the next case, another case which has been referred to, there may be an order of stay.
no, that is what I am submitting.
So what is that order?
No stay is there. That we
Where is that order?
affidavit we have given. Affidavit is there.
Additional affidavit you have filed.
But this is the additional affidavit in which the order has been.
You have
Yeah,
annexed
right.
that order.
But that the order is. No, another I filed because the direction was to file the order. I in the additional affidavit that I have filed. But I have filed also another IA for amendment in which I have submitted that affidavit. That affidavit is.
So what is the stage of the, you come to your additional affidavit, the order
Well,
which you have filed. It says that the learned advocate on behalf of the borrower is also present. Learned advocate for borrower states that another case is pending in the Court of Debt Recovery Tribunal, Cuttack, relating to this matter. This fact also considered by the authorized officer. What is that case is about?
in fact, that is my case, my lord. He has simply said that one case is pending and he has passed to keep it in abeyance. Rather, our affidavit is there that no stay is there from any competent court of law.
But what is that case we want to know?
Whether at all any case is pending or he made a false statement before the collector on
Well, I will get it.
See,
That's the only thing we want.
otherwise there is no problem. The obstacle, any hindrance on the part of the collector to proceed. But such a statement was made regarding pendency of another
Pendency,
case.
my lord. That is not my case.
Huh?
Even
No
if it is
case.
pending, my lord, he cannot keep it in abeyance. my lord.
Then why you considered? Why didn't you, the authorized officer did not say anything? You see that line which my esteemed brother was placing, when the borrower's counsel made such a statement that another case is pending before the DRT Cuttack relating to this matter, this authorized officer considered that.
Authorized officer. That he has considered that one case is pending, but no stay is there.
That we understand, but what
No,
is
I
that
get
case?
that.
We want to know what is that case is about. Whether it has, that case has any bearing with this
Right.
matter or not.
Right.
That's what we want to know.
I will get the entire order sheet.
That's the whole.
Look, Mr. Niyamati, Land Counsel appearing for the petitioner, submitted that as per the order dated 15/1/2025, he has filed the additional affidavit by the petitioner, wherein the order passed by the collector on go, in this case, bracket ray surface area 2002, bracket ends number 14 of 2024, dated 18/12/2024, has been annexed. On perusal of the said order, which has been annexed to the additional affidavit, it appears that when the matter was taken up by the collector on board, the London Counsel for the borrower made a statement that one case is pending in the Court of London Debt Recovery Tribunal, Cuttack, relating to the matter, and that was considered by the authorized officer. Stop for a moment. Mr. Niyamati submitted that no such case. One case is pending. Though one case is pending before the DRT Cuttack, but there is no stay order passed in the said case, and you produce the. Can you tell us the number of that case?
Once I will get the entire order.
The London Council seeks some time to produce the entire order sheet of the case which has been referred to by the collector on board in the aforesaid order dated 18/12/2024. List this matter on Kebekon.
Next week, Manos.
Hmm.
Next week, Manos on Wednesday.
Wednesday. List this matter on 2nd of July 2025. That is the July calendar, right?
Problem.
Item 2.
The matter is pending with the apex court, similar matter. What may kindly see the last order.
10/4/2025. Last order is 10/4/2025.
Yes, yes.
It is stated that Mr. Biswajit Maharana, London Central Government Council, submits that Union of India has filed 2 special petitions before the Honorable Supreme Court, but the same have not been listed, and therefore the matter may be adjourned.
Subsequently, one IA has been filed for vacation of stay, and that has been posted for the last week of July.
Vacation of stay means in the SLP there is some,
SLP.
there is some interim order.
Yes, 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 yes.
And from your side, an application has been filed for vacation of stay.
We are the petitioner there, madam.
What?
The issue.
You are the Union of India.
Union of India is the
Okay.
for the appellant in the.
So the opposite party has filed an application for vacation of
Yes,
stay.
sir.
That is sub judice, and which is posted for on what date?
That not exact date, the last
It's
week
not-
of July, you will see, man.
Okay.
Your lordship may kindly see previous order on 6/3/2000, detail has been mentioned in your lordship's order regarding.
Those 2 SLP numbers, etc.
Yes, yes, and the stay order will be granted. That has been granted.
Interim order has been passed and operation of the order of this court has been stayed. And he has produced the same with the affidavit on behalf of the Deputy Chief Personnel Officer, so and so.
Madam.
6 for to apprise this court about the status of those 2 SLPs which are sub judice. Then you took time on again on 10/4/25. Now what
That
is-
has not been listed in the meantime.
Vacation is going on, it will come after August only.
So
Let it come on August
last week of when apex court is
13th.
there of. Sure. So let it come in the last week will also.
Or not, like first, the opening for the miscellaneous week over August.
Correct.
August.
The Mr. Maharana, Mr. Maharana, Central Government Council has produced the order dated 7/5/2025, passed in civil appeal number 10208 of 2024 by the Honorable Supreme Court. Which indicates that the matter was directed to be listed in the last week of July 2025. The London Council for the Union of India submits that IA number 36816 of 2024 has been filed by the opposite party for vacating the stay order which was passed in favor of the petitioners. And since that interim application has been posted to last week of July 2025 for consideration, this matter may be urgent. So, list this matter in the second week of August 2025. The Land Central Government Council shall apprise this court about the development made, if any, in the opposite to SLP in the Honorable Supreme Court. Yes.
That will be not senior panel council, not senior panel.
Senior panel counsel.
Obliged.
Item 3.
Just similar. During this case, my lord, the order of the learned state administrative tribunal has under challenge, my lord. The learned tribunal has passed that order considering the number of the batch of cases. There are two things in this.
Law is against you.
Law is
You
against,
know that.
law is against us, my lord.
Rafik Masa.
But this is the case that in the year 2009, the NMR was brought to the Worcester department. But in fact, he has joined after 9-10 months after. That's why the department sent the recovery of that. And moreover, another part, my lord, in the year of 17, the law of the both sides have been possible. If they can't recover, and it's not one under the and moreover, the state
This is the,
passes in the year of 17.
Don't
Leave it.
necessarily. The petitioners have filed this petition challenging the interim order dated 21/9/2017 passed by the London State Administrative Tribunal. In way number 1342 bracket received of 2010. It appears that the said way was heard along with other original application as the grievance and relief sought for by the applicants in all the original application are one and same.
Let me be there, chosen to join this matter. You know,
What was the prayer before the original application, where it has been mentioned in the order?
they are saying that the recovery, order of the recovery may be.
पूजा लिखा है जी, अच्छा, it लिखा है जी, on the end of the theological affair, the no illegally doesn't come action, financial, and similar procedure person have been brought up. And all of it was found.
These 32 top right.
32.
Two right up. That's all. No.
Yes, sir. Then also further submits that. The issue with regard to the recovery of area.
recovery of various support.
It appears that the opposite party was working as an enama and brought over to the Warwickshire establishment, and he was paid some amount towards his salary, and the petitioners passed the order directing the opposite party and others who were brought over to the Warwickshire establishment to draw their salary only with effect from the date of joining, and further directed that if any excess amount has been paid, the same should be recovered from the employees. The action of the petitioners in directing for recovery of the excess amount were challenged by the opposite party and other similarly situated persons in the batch of original applications as illegal and violative of the fundamental rights of the applicant. It seems from the impugned order that no counter affidavit has been filed by the petitioners. The London Street Administrative Tribunal formulated the point as to whether the amount which has already been paid to the opposite party and similarly situated persons can be recovered from them or not. Stop. The Land Tribunal relied upon the decision of the Honorable Supreme Court in the case of State of Punjab and others versus Rafiq Mashia bracket. This is white washer or what? Wild washer. In past in civil appeal numbers one dekhi debu sera. Civil appeal numbers one so reported hochi. Eta reported hochi. Taku rely kari amar madhya judgment of the division bench. Chief Justice ko sangu and issued the guidelines and summarized the situation where the recovery by the employer would not be permissible. The London Tribunal further held that since the recovery orders have already been quashed by the tribunal in earlier in OA number 694C of 2011, the opposite party, the petitioners are directed not to take any action for recovery of the amount already paid pursuant to the letters under Annexure 6 and 7. Stop. This court, in the case of Ramapura division, has also taken a similar view in answer. In view of the settled position of law as decided by the Honorable Supreme Court and also this court, we find no infirmity or illegality in the impugned order. Accordingly, the related petition being devoid of merit stands dismissed. Here.
Item 4.
The order number 1 has been, the office has pointed out that the order number 1 has been inadvertently typed as 19/5/2025 instead of 19/6/2025. Stop. The order number 1 shall be read to have been passed on 19/6/2025. Yes, next.
Item 4.
Mission, I am for the opposite party.
Which one?
Item 4, Your Lordship.
This is the item.
What do you want?
It's time to file a counter relative service reports prepared there.
You are appealing for the
Opposite parties.
Union of India.
No, Millard, that next opposite parties.
Union of-
Not separate of India.
Just a minute.
We are appearing for opposite 1 and 2 and 3.
You are appearing then for that
Millard,
Sports Authority of
Sports,
India.
my lord. The 3,
That means
3, 4, 5 and 6.
3, 4, 5 and 6.
2 also, 2.
2 अच्छा
2, 3, 4, 5, 6.
अच्छा ठीक अछि. What about okay, the
Union of
Union of India has filed the counter affidavit.
No, man.
Like to file?
You don't want to file or
They will fail me.
notice has not been issued of the fresh admission. What is your prayer, Mr. Pushpala?
Plus, prayer, Lords, I have challenged in this case the order passed by the Central Administrative Tribunal, by virtue of which order plus the prayer of the petitioners for regular scale of pay and regular service have been rejected, Your Lordship.
All right. This petition has been filed by the petitioners Atanu Ghosh, Ranjit Kunjur, Amit Kumar Patnaik, and Teja Raksha, challenging the order dated. Which is that order? Annexure?
Plus, Annexure
21st of February
8,
2000.
Lords.
Annexure 8.
Lords.
21st of February 2025.
Achha. Order dated 21st of February 2025, passed in OA number 260/00720 of 2019. In rejecting the prayers of the petitioners for a direction to the opposite parties not to dispense with their engagement, and thereby dismissing the original application. The Land Council for the Union of India has already entered appearance for opposite party number 1, and Mr. Lalitendra Mishra, Land Council, has already entered appearance for opposite parties number 2 to 6. And they have also been served with the copy of the writ petition. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Both the Land Council for the Union of India, so also the Land Council appearing for the opposite parties number 2 to 6, seek some time to file counter affidavit. This matter in the week commencing 4 सप्ताह पर पकड़ेगा. Counter affidavit, if any, be filed in the meantime, serving copy on the land council for the other side. Yes.
In the writ petition, you are in the prayer clause, the OA number is
Not correct.
not correct. Just check it out. Only
OA number.
720 of
No.
2019 you have written. There is something else also.
It is that the code of the Administrative Tribunal of Cuttack, that is 26.
But that number is total
that is-
number.
Just mention the entire number, not
yes.
a.
Millards.
It is now 260. Which is that 260? Why it has been added? Because it came to Cuttack.
Cuttack rank.
Earlier it was filed in Bhubaneswar or what?
No, Miller. Central Tribunal.
Acha,
Central Administrative Cuttack.
Sorry, Central Administrative Tribunal, where it was filed, this 720 number.
Cuttack Tribunal.
No, 7
260
is the code of the tribunal.
Millards.
But that is including, that number has to be included.
Yes, I will amend Millards.
You could amend it.
Millards.
Correctly said.
Acha, likhi diyantu, pratham ullekh deben. Mr. Puspalak Land Council submits that inadvertently in the prayer portion, the case number has been mentioned as OA number 720 of 2019 instead of OA number 260 public 00720 of 2019, and he'll file an interim application for correction of the number of the original application. Permission is granted for
Not only in the prayer, in the entire petition.
Oh, आपको आ जाओ. In the body of the petitions, also in the prayer portion, है ना? We'll file an application, so on, है ना? Okay.
Millards.
Straightforward.
Item 5.
4 weeks from the date for filing. You file counter affidavit, huh?
That's of writ application. And some of the writ applications, the specified copy of the interim order is not filed. We have received it. If a lot of people are not some time. It's been filed.
You want adjournment to file what?
To certified copy of the order of the
Impugned
Impugned order.
Impugned order. That was not filed at the time.
No, whether the impugned order is one and same in all the writ
No,
petitions?
my lord, different
order.
different petitioners for.
Different petitioners, but one order.
Ah,
Different petitioner,
But
one
this-
order.
But same order.
Same.
Common order.
no, if the order is common, then if in one application it has already been filed and in other application the Xerox copy has been filed, then application can be filed to dispense with filing
Yes.
because those have to be hard together.
Yes, yes.
And
Separately hard.
huh?
Separately hard. Other date has been passed, separate to file the application, but prayer is same.
Already.
My lord is saying because we are not filing certified copy, this filing of certified copy dispensed with. This should be the order. Yes. Correctly, my lord is saying. Because we have filed one certified copy.
If all these matters are to be hard,
No.
it is it can-
Separately hard.
Oh,
But
it is to be hard separately.
separately,
Then it's so. Mr. Pari, they say that it is to be hard separately,
Separate.
not that.
No problem. Either it jointly
Okay.
or separately, we don't have a.
All right. Who is requesting for adjournment? You, the Union of India.
Union of Union.
All right, দেখুন, WPC number. We are coming by one. The
Yes.
8593 of 2025, you have filed the certified copy.
No, my lord, item 2, Mr. Gupta.
ତୁ କଣ ମ ଆରେ ଗୋଟେ ପଚାରୁଛୁ ପରା 3-4ଟା ଇଏ ଅଛି ପ୍ରଥମଟା କୁହନ୍ତୁ 8593 ରେ ସୁଲୋଚନା ପାତ୍ର ଯୋଉଥିରେ ଅଛନ୍ତି ତା ଦେହରେ ଇମ୍ପୁଗ୍ନ ଅର୍ଡର ସାର୍ଟିଫାଏଡ କପି ଫାଇଲ କରିଛନ୍ତି ଲେଖନ୍ତୁ WPC number 8593 of 2025. Sulochana Patra, what is your designation? CGC, Land and Central Government Council, appearing for the Union of India, 6 of 9, to file the certified copy of the impugned order. This matter on such and such body. Similar लिखी देवे এটারে দীপ্তি রঞ্জন ভুক্তাঙ্গ না লেখা হবো
My lord, this is
ওকে এটা লেখা সেকেন্ডারে ଆଉ থার্ডারে লেখা হবো বিভূতি ভূষণ মিশ্র
স্যার আমি লিস্ট দিয়ে দিই স্যার লিস্ট দিয়ে দিই
এই তিনটা গভর্নমেন্ট চার্জ চতুর্থরে লেখা হবো দর্প নারায়ণ পট্টনাୟକ ସେମାନେ ସମସ୍ତେ ସେଣ୍ଟ୍ରାଲ ଗଭର୍ନମେଣ୍ଟ କାଉନସିଲ
দর্প পটনায়ক সিনিয়র প্ল্যান কাউন্সিল মিস্টার বিভূতি মিশ্রা সিনিয়র প্ল্যান কাউন্সিল
এই শুনো
স্লিপ দিয়ে দিচ্ছি
ସ୍ଲିପରେ ନେଇ ଆସ କିଏ କଣ ଡେଜିଗ୍ନେସନ ତାର ନେଇ ଆସନ୍ତୁ ଏ ସବୁ ମ୍ୟାଟର ଆର୍ଜେଣ୍ଟ କରିଦବୁ ଗୋଟେ ଡେଟ୍ ରହିବ ୱିଥ୍ ରହିବ
My lord, I may be permitted to submit this copy of the petition has already served upon the opposite party. He has received it, my lord.
in which case
Fourth, no, yes, my lord.
that is
8934.
WPC number 893
8934 of 25.
you have received the
Yes, sir.
copy
Yes, sir.
all right ଲେଖି ଦବ ଏ ଯୋଉ ଲାଷ୍ଟ ଟା ଅଛି WPC number 8934 of 2025 Mr. Patnaik Land Council for the Union of India submits that he has already served a copy of the writ petition on Mr. Smarati Land Council opposite party, which is not disputed by the Land Council for the opposite party. Sati condition. बाकी ए प्रत्येक मैटर विथ आ संगे राशिव सी ता संगे राशिव एमती करी गोटे डेट रे पकई देन हला यस और तोले लिखिबे सर्टिफाइड कॉपी ऑफ द इम्प्रूव्ड ऑर्डर बी फाइल इन द मीन टाइम राइट यस
Item 6.
Item number 6,
Mr. Sahu
my lord, in this matter, my lord, I am for the petitioner, my lord.
yeah
He got the instructions, bank,
My lord,
75 lakhs you will deposit.
60 lakhs have been deposited, but regarding the OTS, they have not in.
75 lakhs you are supposed to deposit.
Yes,
You have got delayed
My
in
lord.
making the payment. He was supposed to get the instructions.
No, there was no agreement between the parties for the OTS amount. He had earlier approached to this honorable court, made a writ petition. Then he offered that amount, so this honorable court said, okay, you paid the 50 lakhs.
ଲୋକଡା ଗୋଟେ ରାଜି ଅଛି ଦବା ପାଇଁ ଆପଣ କେତେ ଟଙ୍କା କଣ ଏଥିରେ ବୁଝି ପାରୁନି
Total number of parties, I will go, my lord.
ଟିକେ ଟିକେ ରୁହନ୍ତୁ he ଆପଣଙ୍କୁ କୁହାହେଲା ଯେ he is now ready to pay 75 lakhs if you say no that amount is not 75 lakhs but it is more then please bring that instruction so that he will
My lord,
take
I got that instruction. I'm
what
sorry.
is the amount tell us
My lord, the amount is as on today, 1 crore 17 lakhs.
so file by way of an affidavit
And,
that amount
Yes, bank can settle 85 lakhs.
just bring
If
it
he
on
pays
it's not,
within
not
this
your
month.
oral submission Land Council the one of the authority of the bank like the branch manager or somebody should file an affidavit that if this amount is paid by this date maybe by installment or otherwise apart from that 60 lakh which has already been paid the bank is ready and willing to settle so give a copy of that affidavit so that he will take instruction
But I'll file the.
What you say is one
But I'm making
crore
a
17
condition,
lakhs
I
is the due.
this-
85 lakhs if he pays, it
Maybe
will
this
close
month,
it. That's
we'll
what,
close it.
within a month.
Due is one.
we are mentioning it but bring it on otherwise tomorrow you may change the stand
No, I'll not change that.
No, you have.
I'm a lawyer, Miller, officer of the court. I will
not in that way भीतर आउ interest ହେଇଗଲାଣି so
within this month, if he
not
pays.
you means the bank sometime in this type of matter मासे आज्ञा भीतर ହେଇଗଲାଣି ଆଉ ଟିକେ ଅଧିକା interest
ଆଜି message ପଠେଇଛନ୍ତି.
so we are mentioning it so ଦେଖନ୍ତୁ
85 lakhs within 1 month. He paid, finished.
Within this month, only, within this month.
ଦେଖନ୍ତୁ Mr. Panigrahi Land
End of this
Council appearing for the
Just the offer.
End of this month, now, the 3 days.
For the
No, 75 lakhs he was to pay by
Try to
March.
be practical. That is the reason the banks are at loss always.
For that reason, ICICI Bank is not.
Try to be reasonable. Within 2 days, I will, where
No,
from?
how clean hand, Millard, I'll submit if he allows me on legal on merits, Millard.
no, we are on a point to decide the matter so that that is in the spirit of Lok Adalat you just try to otherwise if you be that strict in
sir, we are
no
giving-
matter can be
No, we are giving discount of 30 lakhs more, Millard. Earlier it was
It
1
will
crore
always
70
give him
lakhs.
some time. He has rightly said that only few days are left for this month. So you say that by 30th if they will pay. So be
I
reasonable.
submit one thing, Millard.
At the end of July,
Either he can approach the bank with a fresh proposal, we will dispose of within 5 days. That's a submission, Millard. Or the earlier proposal, the bank will dispose of within 7 days. The earlier proposal he has given.
Proposal में amount अपनो
Amount I am stating 85 lakhs within this.
Hurts me.
We
They
can
reaching
keep- we can
30
keep-
days from their own
Just-
house.
just-
they
just a minute.
stated.
1 minute.
we can
30 days
keep-
means
Mr. Sahu,
My
Mr. Sahu, we can keep this matter even to day after tomorrow. Just convince your authority, bank authority, to give some more time. Till that the honorable judges and that is his submission is facing difficulty, some more days time so that the amount can be given. It's not that if 1 more week or 2 more weeks is given, heaven will fall. Maybe that. So ultimately, if a matter is settled, how the clients will have the confidence on the bank. If they will be harassed by the bank, you have given the money, it's right, all right. He faced some difficulty. He could not repay the loan amount in time. That is how he is paying the interest. But for that, he wants some more time. And it will be resident of that by 30th, if he pays the, he's facing difficulty.
That
So
was the offer.
try to convince,
We'll consider this day after tomorrow.
All
In the
right.
meantime, we'll file a small affidavit also.
You come with that money, 85 lakhs, get ready to pay.
By March, he was to pay 75.
No, he will pay within 15,
Mr.
20 days.
Panigrahi Land and Council appearing for the opposite party number 1 and 2 submits that as per the order dated 18/6/2025, he has received the instruction from the bank that the outstanding dues against
Page up,
the
please. 1 lakh.
petitioner as on date is rupees 1 crore
17 lakhs.
17 lakhs.
17 lakhs.
5,443.
17 lakhs 5,000
443.
5,443 amount that is selected. However, the bank is ready and willing to settle the loan account if the petitioner pays a sum of rupees
85 lakhs.
85 lakhs by
30th.
of June 2025. Stop.
Submission.
Mr. Sahoo Hon'Ble counsel for the petitioner expressed the inability of the petitioner to deposit such amount within this short period, and he seeks some more time to clear off the amount as suggested by the the land council for the opposite party number 1 and 2. Stop. List this matter on 25th of June 2025. The land council for the opposite party number 1 and 2 shall file an affidavit in that respect, giving the approximate time and the amount which is to be paid by the petitioner. And Mr. Sahu shall also obtain instruction from the petitioner regarding payment of such amount as suggested by the land council for the opposite party number 1 and 2. Allah, put up this matter on such and such various.
Item 7.
Item number 7, I am for the opposite party in first case. So
Mhm.
nothing is that after the not filed, within a week I will file my okalatment. And in second case, I have already filed my okalatment. But there is a noting that a memo has been filed by the petitioner. That is the memo that.
Just a minute. Appearance memo by Mr. S. Behera.
My director.
Acha. You are appearing for Union of India.
No, ICR.
Judges.
ICR.
हाँ,
appearing for the Union of India.
चलो,
I am for the panel council of ICR.
ठीक है, just a moment. There are 4 opposite parties.
I am for open number 2 to 4.
I am for the open number 1.
Right, all right. So now, what do you want in this matter?
And next week I will file my okalatment.
Which for the petitioner? You are for the petitioner. The land council for the petition. What is your good name?
Ashish Ranjan.
Ashish Ranjan Mahanti is present. Stop. The land council for the Union of India, Mr. Swanso, and the land council for the opposite parties number 2 to 4. Mr. Swanso, Mr. Behrana,
No.
is Behra, are present. Stop. Mr. Behra submits that he will file wakalatnama for the opposite parties number 2 to 4. during course of this week.
Next week.
Acha, by next week. And the matter may be taken off on some other day, stop. Learned counsel for the petitioner has no objection to such adjournment. Please this matter करेगा गोटे सप्ताह छाड़ दी तापर सप्ताह रखी देली आपण 7 तारिख रे रखी देली. We commencing from
I am the petitioner connected case, my lord.
just a minute, 7th July 2025. Connected case relakontu. The learned counsel for the petitioner. What is your good name?
Prashant Kumar Sahu.
Mr. Prashant Kumar Sahu is present. The learned counsel for the Union of India. So also.
Your Lordship, I am appearing for Union of India. OP number 1, Your Lordship.
Acha. You are Mr.
Milan Kumar, Your Lordship.
Milan Kumar. Central Government Council.
Yes, Your Lordship. Yes, sir.
Central Government Council
I'm from student.
is present for Union of India and Adhiraki Achandu. And the Mr. Behra, Learned Council,
Number 2 and 3.
submits that he has instruction to appear for
Already
opposite.
filed,
Acha.
clerk.
He has already filed for opposite parties number, filed wakalat number for opposite parties number 2 and 3. Stop.
There is a noting that a memo has been filed by the petitioner. What is that memo? Already a serve memo.
We have not received the memo.
Already received. Already received. Received already. Received.
कौन से मेमो कौन फ्लैग
Say no, the judgment of Notor Mahanti in the court of Tribunal. Order of Tribunal. That already filed is copy दिया है.
से हमें कहिथिलु जो ऑर्डर डेटेड 21/2025 थे जे similarly situated employees styled as Nodvar Mahanti versus so and so was dismissed. It was in similar case examine करेगा, but in the memo रे समान कहउचंदी that the petitioner's case are not similar to the case of Central Administrative Tribunal. So the OA number जो Nodvar Mahanti case संगे similar नुए बोली लिखी जाऊँ. A memo has been filed which is at flag A. It a second item रे लिखी, wherein it is indicated that the case of the petitioners are not similar to the case of Nodvar Mahanti versus Indian Council of Agriculture as mentioned in the order number 1 dated 21/2025. है ना? Yes, it has to be first item. 7 7/2025 both the matters will come. Yes.
Counter to file करो. Not file counter to.
Let it come. The notice has not yet been issued. So you have to hear the
matter is entertained.
Because the initial stage there was an objection from the side of the Central Government Council that one similar matter has already been dismissed. That is how he was supposed to read it and order and give a reply, and that is how you have filed that memo, wherein it stated that Nodvar Mahanti case is different. So let us hear it on 7/7.
Okay.
All right. Yes.
Item 8.
Mr. Das.
Yeah. So here the order of this one says.
You are appearing for Union of India. Union of India, you are appearing.
Yes, madam.
You are.
CGC.
You are respondent. Yes.
My lord, the order of the Central Administrative Tribunal is under challenge, my lord. Short question is that
The order is dated 26/7/2024.
yes, madam.
Under Annexure 5.
Annexure 5.
What was the prayer made by the opposite party?
To quash the order of suspension, my lord.
Okay, and ultimately what has?
Ultimately, my lord.
Come to page 58. Page 58.
Yes,
paragraph
57 and 58, madam.
Huh?
Page 57 and 58.
57 place କରିବାକୁ ଚାହୁଁଛନ୍ତି ଆଉ ପଢନ୍ତୁ.
Paragraph 6. Subsequently, similar question as to whether, while continuing under suspension, allowing an employee to retire on attaining the age of superannuation without any objection, the order of suspension automatically get revoked after the relationship of master and servant cease to exist
came up for consideration before the CAT PB New Delhi in OA number such and such. The CAT PB New Delhi, taking into consideration the earlier decision in the case of RS Naik, HL Mehta, and various other decisions, Rules 65 and CCS Pension Rule 72, and the fundamental rules of FR 53, 1 FR 54(3) and FR 56, etc., while order dated 22/2015 held that since the applicant therein, while under suspension, was allowed to retire by respondents on attaining the age of superannuation without any objection, the earlier period of suspension automatically gets revoked, and the relationship of master and servant between the government and the employee cease to exist on retirement, and his status as employee get altered. Accordingly, the respondent therein were directed to release the benefits of pay and allowance, etc. On examination of the fact and issues involved in this case, vis-a-vis a case law referred to above, we do not find any ground to differ from the view already taken by CAT PB New Delhi that since the applicant in the instant way, while under suspension, was allowed to retire by the respondent on attaining the age of superannuation without any objection and without any initiation of departmental proceeding, the order of suspension automatically spends its force and becomes redundant and ceases to exist. So it resultantly entitling him to pay and other allowances for the period of suspension as if spent in duty. Hence, the respondent are directed to pay the applicant his salary and allowances with effect from the date of payment. The order relied upon by the
It was challenged before High Court.
Yes, ma'am. The order relied upon the mention the order which was mentioned in paragraph 7, my lord. The last may turn to annexure 7, my lord. Page 116, my lord. The relevant portion is page 127, my lord. All this is judgment relied upon has been preferred to the division bench appeal, my lord. You'll also see. You'll also got that. So, yes. Para 20, my lord.
It's a Delhi High Court judgment.
Yes. The order passed by the PB bench, my lord, New Delhi, CAT, it was preferred, my lord. It would be extremely easy for a government servant to commit acts of impropriety which may or may not cause financial or other loss to its employee, and consequently being suspended on charge for such act, and irrespective of the outcome of such departmental or judicial proceedings, he should comfortably walk into the sunset with full retirement benefits simply because he was allowed to retire or superannuate from his service without any objection. The aforesaid rule deal with the delinquent employee being granted full pensionary benefits merely upon his superannuation, though he is facing disciplinary or judicial proceeding. 1981 rule relating to compulsory computation of pension were brought into force. Rule 9(4) and Rule 69 of the 72 rules are not under challenge. Its meaning and import is clear and unambiguous. They govern the circumstances such as the present case, where a government servant against whom departmental or judicial proceeding have been initiated before the date of his retirement and continue even after retirement. Indeed, the rule clearly puts a restriction on the continuance of full pension, etc. The pension has to be reworked and calculated on conclusion of judicial proceedings.
So here no departmental proceeding has been initiated.
But here, what has happened? Departmental proceeding has been initiated after his retirement.
So,
because, my lord,
that makes the difference. Suppose it has not been initiated.
Yes, that is it. Because what has happened, my lord, we have given the reasons, my lord. Because the case was handed over.
Reasons you may give in. You may.
Yes, this case was handed over to CBI, my lord. The CBI has seized all the documents. After after his retirement, the documents has been released by this.
No, we are on
thereafter, my lord, we have initiated.
We are on a point of law.
Yes, that is an admitted fact.
You convince us that suppose a departmental proceeding has not been initiated till the person retires. So thereafter also you will you will not give the that pension amount in full. So that is the exact thing which has been directed by the. So salary and allowance with effect from date of suspension.
Yes.
till his retirement of the case minus the subsistence allowance. Subsistence allowance 50% মনে দৌথিবে বা so it's all right minus it paid to him so and so. To convince us that Delhi judgment, division bench judgment says in that case the departmental proceeding has already been initiated.
Yes.
And in that way he was
On that ground, said that reliance on that point.
but here is a case where factual scenario is different. So in such a case, also the person concerned is not entitled to his salary and also the pension amount in full. So was the decision.
Even after after the retirement, sir.
Yes.
After how many months you have initiated?
1 year and some.
When he retired, then can you tell us the date of
retirement? The date of retirement is date of retirement is 31/1/2022.
31/1/2022. And when you initiated the DP?
In 24, my lord.
1/11/2024. 2024.
Yes.
Are you ready with the decision or you want some time?
No, I have not read.
Get it.
That point.
That's the only
No,
point.
that is the only point.
That's the only point.
Legon, this writ petition has been filed by the Union of India challenging the order dated 26/7/2024 passed by the London Central Administrative Tribunal in way number 260/0067 of 2021. In holding that since the opposite party, Deepak Niranjan Nath Pandit, who was under suspension, was allowed to retire by the petitioners on attaining the age of superannuation without any objection and without any initiation of the departmental proceeding, the order of his suspension automatically spends its force, becomes redundant, cease to exist, resultantly, entitling him to pay and other allowances for the period of suspension as if spent in duty. And thus, the petitioners were directed to pay the opposite party his salary and allowances with effect from the date of suspension till his retirement, minus subsistence allowance already paid to him. Stop. The London Council for the submits that the London Central Administrative Tribunal relied upon the decision. এই ডিসিশনটা সে রিলাই করছেন না নাই করনা
এই ডিসিশনটা রিলাই করছেন
which paragraph?
Paragraph 7
ଯୋଉଟା ଆପଣ ରେଫର କରୁଛନ୍ତି annexure 7 ରେ
yes
ଏଟା କୋଉଠି ରେଫର କରୁଛନ୍ତି ଏଟା ହଉଛି ପାର୍ଟି ନା ହେଲା ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ ଭର୍ସେସ ଏସକେ ଗୁପ୍ତା କୋଉଠି paragraph 6
yes
Land Council submits that though the Land Tribunal has relied upon the decision of the division bench. Who did rely upon that? No, he has not relied upon this decision.
Well, the division bench judgment? Last paragraph. Judgment.
No. Yeah. Central Administrative Tribunal upon कहले इटा rely करछेंदी बोली, but whether that is factually correct, we don't think so.
Para 6 रे rely करछन.
Para 6 रे
Page 57.
57 रे rely करछेंदी सेटा होची सुरेंद्र कुमार गुप्ता versus Union of India.
Yes.
एटा को से ऑर्डर टा चैलेंज हला डिवीजन बेंच.
Yes.
रे सुप्रीम सेटा हला but we find that the order which was relied upon by the petitioners was of the division bench of Delhi High Court, passed in WPC number 11860 of 2015, that is Union of India and another versus S.K. Gupta, in which the division bench has been pleased to hold that where a government servant against whom departmental or judicial proceeding have been instituted before the date of retirement and continue after the retirement, the 1972 rules, so also 1981 rules, put a restriction on commutation of full pension, etc., and therefore directed that the pension has to be reworked and calculated on conclusion of the judicial proceeding. The factual scenario of the aforesaid case, which was relied upon by the learned counsel for the petitioners, is different from the present case, in as much as till the opposite party retired on 31/1/2022, no departmental proceeding was initiated against him, and it was only initiated on 1/11/2024, as stated by the Land Council for the Union of India. Stop. At this stage, Mr. Das and senior advocates seek some time to show some citations on the point that even if the opposite party has been placed under orders of suspension and he was allowed to retire on attaining the age of superannuation without any objection, and thereafter the departmental proceeding is initiated against him by the petitioner, the opposite party would not be entitled to his salary and allowance. Stop. And it would be subject to, when I say the continuable, it would be subject to the result of the departmental proceeding so initiated after the date of initiated after the superannuation. Date of superannuation. List this matter on Kebe Rakhiyo Phone.
First week of July.
List this matter in the week commencing from 7th of July 2025.
In the meantime, they have filed a contempt before the tribunal.
ଆମକୁ ସାଟିସ୍ଫାଏ କରନ୍ତୁ, ତାପରେ ଯଦି ଟାଇମ୍ ନେଇଯାଆନ୍ତୁ ଯେ ଏମିତି ଅର୍ଡରଟା ପାସ୍ ହେଇଛି ତେଣୁ ଆପଣ 7 ତାରିଖ ପରେ ରଖନ୍ତୁ ହେଲା। ନେକ୍ସଟ
The name of CBC may be
indicatable. Yes, sir.
CGC.
এটা আচ্ছা and also the Mr. A.S. Das, Land and Central Government Council.
Item 9.
Very brief. So there are two matters. Earlier I approved this level board matter. And if you also look at unaccepted 8 page 24. That was below the disposal of withdrawal.
Now, who is appearing for Gramya Bank?
I'm
You are.
Withdrawal below to approach the bank. I will approach the bank in annexure 9.
Which is the earlier order you say?
That is page 25 now.
In the first item?
Yes.
Annexure?
Annexure 8, relevant page below page 25.
They have approached the bank.
Yes. To appear on behalf of, he has no objection on proposal to approach the bank for appropriate relief. Okay, you actually the demand notice.
Yes.
Dated 14/11/2024, issued by the Gramya Bank, Dhenkanal branch.
Then annexure 9 mirror, I filed application for OTS.
No, the same demand notice was earlier challenged.
Yes.
Where you have withdrawn and
Yes.
and approached the court, approached the bank. That's what we were.
Full amount mirror for OTS. And that was declined mirror without any reason. Annexure 11 page 33.
But that was declined.
Just we'll hear you, just after saying. Yes.
Annexure 11 page 33.
Yes.
But in my application before the bank, I have highlighted certain amounts which have been paid has not been reflected. And according to my I have submitted the application. And in the meantime, kindly come to annexure 12, page 34. Bank has approached my litigation mediation proceeding 24. That is going to be here on 25. 25/6.
Before the
So, but I just want my, I just.
Let us wait. Why to do it?
Take up this matter on 7th July. Apprises this court about the status of
mediation. What happened during subsequent of mortgage? They have transferred the property by way of sale to a third person, and they are offering 50% of the total use, which was declined.
ଆପଣ ସେଇ litigation mediation proceeding ଟେ କୁହନ୍ତୁ ଏଗୁଡା। Let us see what
ଆମେ କାହିଁ ବର୍ତ୍ତମାନ ତା ଦେହରେ ପଶିବାକୁ ଯଦି ହେଇପାରିଲା କିଛି ସେଟଲ୍ ହେଇଗଲା ଭଲ ଲେଖନ୍ତୁ the writ petition has been filed by the petitioner Dolly Bhutia challenging so and so on. Mr. Tripathi Land Council appearing for the petitioner submits that earlier the petitioner approached this court in WPC number 4162 of 2025 challenging the demand notice dated 14/11/2024 issued by Odisha Gramya Bank Dhenkanal branch. But the writ petition was disposed of on the prayer of the petitioner as he wanted withdrawal of the writ petition to approach the bank for appropriate relief. Stop. Mr. Tripathi further submits that the petitioner submitted a representation before the bank requesting for one-time settlement under Annexure 9, but the same was rejected by the bank, and now the bank has approached for mediation, and the matter is sub judice in the High Court of Orissa Mediation Center, Qatar, and notice has been issued to the petitioner. এটা কোন নোটিশটা ইস্যু হয়েছে কোন
appear করকি now it has been fixed to 25/6.
না ঠিক রন ये नोटिस टा आपण देइचंदी एटा माधव भूतिया ना लिखा है जेरा पर डॉली भूतिया आजरे
ସେମାନେ ଦେଇଛନ୍ତି ବେଲା borrower
Madhav Bhutia is one of the guarantor.
अच्छा तादिरे किंतु डॉली भूतिया को भी नोटिस है
yes, yes.
all right notice has been issued to the petitioner and petitioner has already entered appearance
Yes.
and the date is fixed to kebe kohile
25/6.
25/6/2025 and the matter may be taken up in the second week of July 2025. The land counsel for the bank, Mr. Sarangi, doesn't dispute regarding the pendency of the matter before the mediation center stopped. This matter in the week commencing from 7th July 2025. Both the parties shall apprise this court about the development made, if any, in the mediation. Yes, this matter along with for the WPC number 11086 of 2025. Yes.
Item 11.
This is procedural answer, but yes.
In this case, procedural direction on 17th, I have already saw the copy.
Who is the cavator? You have received the copy of the report?
Yes, ma'am. They have not executed the document. They say that we do not know about the mortgage, but they have executed the document of guarantee and the mortgage also.
As well as Rule 8, they have issued a notice for
Alternate remedy
issued under Annex 4 minor at page 26 minor. So here the petitioner's son is the borrower and the present petitioner has been shown as the guarantor. At
But
this-
why are you not going to DRT?
The present petitioner ready and willing to pay the.
Hey, you go, section 17 is open for you.
In view of, as your lordship knows, in view of section 30.
No, we will not.
In it, I am ready and willing to pay the entire amount. Then it's-
We are not here.
We are not, number of decision of the Honorable Supreme Court, this court, the FSI Act, alternative remedies available to.
You go and tell that court.
You will get reason.
Like, this petition has been filed by the.
Liberty may be given.
Yes, that will liberty. That Nanda Kishore Panda with a prayer for such answers. As for the order dated 17/6/2025, copy of the petition has already been served on Mr. Dey, who is appearing for the Indian Bank. Mr. Dey raised a preliminary objection that alternative remedy is available to the petitioner to challenge the action of the opposite party and therefore this writ petition is not maintainable. In view of the settled position of law, in case of so you alternative remedy section 17. We are not inclined to entertain this writ petition. The petitioner is at liberty to approve the left recovery tribunal under section 17 so.
Item 12 is also.
And it is made clear that we have not expressed any opinion on the merits of the writ petition. This one kitchen I kitchen.
12 is.
12.
Okay.
Item 13.
Please, ma'am. My lord, here, the petitioner is a loanee availing the loan, my lord, for a trawler, and the loan amount of rupees 64 lakhs or more money has already been disbursed in his favor. So unfortunately, he was going on making.
14 proceeding has already been initiated.
Sir, already been initiated.
So you go to the appropriate forum, challenge it, will not entertain this application.
Because my lord, only one prayer, I am ready to make the payment. Only
This writ petition has been filed by the petitioner so and so, challenging the order so and so. In view of this, say 14 against the alternative remedy, addition they will court for them. Accordingly, the writ petition is disposed of giving liberty to the petitioners to approach to seek for appropriate remedy. It is made clear that we have not expressed any opinion on the merits of the. Yes, next.
Item 14.
I have 14, either 14 against 2 or
14 against
4.
13.
13 to 13, 4 against the first, 8 hours, 14 against the next. Yes.
Item 14.
This case, I want to withdraw the writ petition because already the settlement has been made with the bank.
All right. Please file a memo. Please file a memo. Now we are giving you the just file a memo. A memo has been filed by the land council for the petitioner that the settlement has already been made with the Bank of India, and therefore he does not want to place this application. Accordingly, the memo is taken on record. The petition is disposed of as not placed. Yes. Please file the memo.
I am for the back.
Mr.
M.K. Mahapatra.
Mr.
M.K. Mahapatra.
T9 also appears for the State Bank of India. No? You are appearing for State Bank of India? Yes.
Item 15.
So this is a case.
Mr. Mahanti's name is still there.
Yes,
Yes.
most unfortunate man. It was a nightmare for all of us. The night he.
Yes.
My lords, this is a case where, my lords, petitioner was one of the premium industries of Orissa. My lords. It was a small scale industry.
Who is appearing for opposite party number 2? You are appearing?
Mr. Padi. I am being led by Mr. Padi. Mr. Padi is on his legs. My senior may start with Mr. Padi will join us.
Okay.
Please.
Well, this is the case where the petitioner company was one of the premium companies of Orissa. Now, my lords, the super cyclone, for 22 years they had been running the company, and my lords, they have received various national awards and other things. Now, what happens, my lords? The super cyclone comes. This is a factory which manufactures high density polyethylene sacks, my lords. High density polyethylene sacks are granules, my lords, which are made out of petroleum, and those are small granules that is converted into fabric, and fabrics are made into sacks. These are the sacks in which, my lords, fertilizers and other products are sealed, not the crops, my lords. Fertilizers and other, my lords, products, industrial products are sealed, so that, my lords, there is no leakage to the products, and that is why, my lords, these sacks are utilized. These are known as high density polyethylene sacks. Now, what happens in 99? There is a super cyclone, my lords. The entire raw material got wasted, which was pledged to the State Bank of India. Now, they apply for apply to the insurance company for settlement of their claims. As usual, my lords, the insurance company backs out, and, my lords, there is a protracted litigation. Award is passed in our favor, upheld by the High Court, upheld by the Supreme Court, my lords. And ultimately, the amounts have been paid, and bank which has given us OTS has already been settled. This is just the brief background. Now, my lords, the background with EPCOM. My lords, your lordship is aware that BIFR was there for medium scale industries, but there was no such institution to take into account the grievances of the small scale industries. So there was a district committee known as SLIC. We applied to the High Court that let the district committee at least consider our grievances and accordingly make proposals for revival of the unit. Now, this honorable court, my lords, they say that all the financial institutions should get together, and I have quoted the order at running page 6. They should get together, formulate a policy to rehabilitate our units. The lordships may kindly see page 6, where I have quoted the order in extenso.
Yes.
Lordship, third cover, the petitioner has filed challenging the action of the financial institutions of 789 and not implementing the guidelines prescribed by the Reserve Bank of India and Small Industries Development Bank of India for providing relief measures to small-scale industrial units affected by natural calamities. The petitioner further assails the indifferent attitude of the said opposite parties 7, 8, and 9 in not participating in the slick proceedings for revival of the petitioner's unit. In WPC 8591 of 2009, the petitioner has assailed the order of attachment of immovable property dated 17/4/2009, issued by the recovery officer, Debts Recovery Tribunal. During the course of hearing for the financial institution or 7, as there are no huge financial dues outstanding against the petitioner company, it should be directed to deposit some amount towards loan dues to show its bona fide and approach the concerned financial institutions for refacement, restructuring, settlement of loan dues. Considering the submissions made by the learned counsel for the parties and without expressing any opinion with regard to the merits of the case, we direct the petitioner company to deposit 10 lakhs with each of the opposite parties 7, 8, and 9 by January 2010 and file necessary applications for refacement, restructuring, settlement of loan dues, furnishing the details on the basis of which such relief is claimed. The financial institutions, that is OPs 7, 8, and 9, shall consider the same on its own merits and in accordance with the guidelines, if any, of the Reserve Bank of India and Small Industries Development Bank of India. In that regard, all the three financial institutions, that is OP number 7, 8, and 9, are directed to convene a joint meeting under the leadership of the State Bank of India, to which the petitioner company shall be called for considering the modality of the settlement of the loan account and take a decision thereon by the end of February 2010. Petitioner shall cooperate with the three financial institutions to facilitate proper and expeditious disposal of the matters within the said date. No coercive action or rest of the order follows. Now, pursuant to this order, my lords, I deposit 10 lakhs with each of the financial.
You are also one of the writ petitioner. You are also one of the writ petitioner.
I was the writ petitioner, sole writ petitioner.
Okay.
And who was the
7, 8, and 9 is EPCOL, OSFC, and State Bank of India.
What happened thereafter?
Thereafter, my lord, your lordship kindly says Annexure 2 onwards. I am giving your lordship the sequence of dates, sequence of events, my lord. So we write to EPCOL, my lords, under Annexure 2 to the managing director. With State Bank, my lords, because they were the first lien holders of the stocks, we have already settled it by way of an OTS. We have already settled it. Now, here, my lords, by Annexure 2, we write to the managing director, EPCOL House, refacement, restructuring, settlement of overdues with reference to the Honorable High Court's order dated 2012-2009 and 23/2/2010. We have to submit viability report and finalize by the end of April 2010. While preparing the refacement restructuring proposal, it is now understood that EPCOL has formulated policy for settlement of dues under OTS. We understand that by availment of this scheme, it would be financially beneficial for the unit. We therefore request you to kindly confirm the amount payable under OTS policy so that we would be in a position to decide settlement of dues either way, refacement or OTS by the end of April 2010. This is what we give. This is Annexure 2. Thereafter, Annexure 3, your lordships may kindly see at running page 20, the EPCOL writes to us. To the Managing Director, Susri Plastic, dear sir, subject one-time settlement of your dues, with reference to your letter dated 13/4/2010, we have to say that as directed by your board, our board OTS policy of EPCOL has been forwarded to state government for approval. We are expecting for government approval soon, after which the pending applications for OTS would be considered under the OTS guidelines formulated by the corporation. Please note that a formal OTS application from your side is yet to be received by us, which shall accompany with 10% of the principal outstanding as initial payment. On receipt of your formal OTS request, we shall process the matter accordingly and finalize the OTS amount. This is for your information and necessary action. So they clearly make us an offer. I just pause here for a moment. They clearly make us an offer. You deposit 10%. We will consider your case for OTS. And we will also intimate to you the amount which will be decided under the OTS policy. So, Your Lordships, these are the receipts by which we have paid that those amounts. Then Your Lordships may kindly see Annexure 5, which is at running page 24.
That amount is 10 lakhs.
This we have deposited, sorry.
Yes.
We have deposited 20 lakhs 85,000, required to deposit 20 lakhs 85,000. We have deposited 10 lakhs and then after we have deposited the entire amount. Annexure 7, Your Lordships may kindly see. That is at running page 26. Letter dated 7/7/2011 by the EPICOL to the Managing Director, Susri Plastics. Dear Sir, the Government of Orissa and Industries Department Resolution 26/5/2011 have approved the OTS scheme for EPICOL and the same government approved scheme has been adopted by EPICOL. While adopting the said scheme, it has been decided that the applicants who have applied under the old scheme will be asked to apply afresh under the new OTS scheme. Your company had expressed to EPICOL wide letter number such and such for settlement of the loan dues of EPICOL under the old OTS scheme, and the said old OTS scheme has been suspended by EPICOL without depositing the initial deposit. We are enclosing herewith.
Sorry, I don't want to interrupt. There are 5 cases. Let's tell you Lordships. The little background. I'm for the response. There are 5 cases. All were heard together by this court. On the ground that we as EPICOL had withdrawn our OTS scheme on the ground that it is not beneficial to us. 5 petitions, one of the petitions, Mr. Kananga was also appearing. All these 5 petitions are heard together, and whether EPICOL has a right to withdraw the OTS scheme, and thereafter we floated on new scheme 2016. All these rates are heard in elaborate hearing of this court. Because the facts were slightly different, court directed all judgments to be passed separately. In fact, 3 judgments came where the court held the right. In fact, the prayer philosophy is, all this background are not relevant. The prayer is that we should be allowed to be accepted the modified OTS scheme of 2007. That's the prayer. Now, 2007 has been withdrawn by people. The question is, can we withdraw? The question has been directly heard, answered by this court. Yes, they can withdraw, and they have no right. The writ petition is there for law. In fact, the matter has gone to Supreme Court. I'll tell you, Lordships.
What happened in the
I'll tell you. Supreme Court they went. Mr. Kananga was also appearing in Supreme Court. Supreme Court confirmed it. Supreme Court confirmed.
You have a right to withdraw.
They have a right to withdraw.
Yes.
Now the question is, before I'll be failing in my duty if I don't say so. That out of the 3, one was confirmed by the Supreme Court. I've got the Supreme Court order also and the High Court order. In one matter, it's like discussed before a different bench. The bench said, I also got that order. Said that consider if anything can be worked out. That matter is still pending in the Supreme Court. Justice Partiwala is the second. Justice Surya Khan was the first order. They dismissed. In principle,
as of today, do you have any OTS scheme or not?
We had an OTS scheme in 2016, which is never availed. We had in 2016, which is never availed.
He is insisting for 2007.
He is insisting on 2007. We had now the question before the Supreme Court is second matter. But the first matter philosophy matter is covered by the judgment of High Court. To that extent, not first judgment, Mr.
No, let me play the facts. Let me play the facts. Thereafter, we are directly covered by Devi there. Devi Dayal has been dealt with. Now let us come to the fact and let's come to the judgment. No. Supreme Court.
Hard and de-hard.
No, not different. I am this. That is why these matters were segregated.
Not segregated on facts. Facts only, but all facts.
If they are segregated on facts, and if my facts.
What are submitting to your lordship? Subject to your lordship that in law it has been decided that the people has the right to withdraw in their interest, because it was not in the financial interest that the property was more. If you lordship see the original judgment of the High Court 5667, we are given 2 copies. It was dismissed. This point that can you withdraw? He said the answer is yes. The High Court. Then the matter went to Supreme Court. He was appearing himself, and it was dismissed. Thereafter, when the other matter of a similar nature went to the Supreme Court,
he said, my lord said, it was having copy.
Yes, yeah, no.
We request,
Who was?
the order was,
So,
yes, the second order. The second order also will be picked also that second order your officers. Second order, we request the officers, Mr. Tariff, the learned council appearing for the corporation period to ascertain whether there is any other way out for the petitioner to save his factory premises, the plot in question, but make some reasonable amount to the corporation. This matter is not what will happen, or what can be the reasonable amount. Reasonable amount would be that what is calculated in 2016, because 7 is gone, with the interest accrued thereon, because had he done in 2016, he would have paid X amount. If he doesn't pay that X amount now, then what would be in 2025 is another matter for computation of the court. That matter is pending in the Supreme Court. So whether your lordship would like.
And long and short of the matter is, you are ready and willing to consider the case in 2016 scheme, not 2017
We are
scheme.
ready and willing, we are not said that we are ready and willing, subject to order of the court.
That's what it's reflecting here.
It is reflected is, my lord.
You have to, in this case, you have to consider 2016 scheme.
2016 scheme with the interest accrued thereon.
Yes, that's a different matter. Mr.
With the interest accrued.
Pari, question is that whether in view of this order,
Yes.
whether the case of the petitioner, which now
What I would
is
take
argued
lordship
before us,
matter
whether
would
that
be
can be
matters of-
considered.
Matter can wait the
2016
Supreme-
scheme at least.
No, my
Will you know what my learned brother is asking is 2016 scheme, will you consider their case?
That your lordship may await the Supreme Court order. I have that much answer to lord.
Malons, last time
You
we had
considered
come up
that.
before, we had come up before another bench.
This matter
Malons.
was listed on 6/3/2025 and it is
Now,
adjourned.
after vacation.
Thereafter, it has not been listed.
Vacation.
Malons,
So as your lordship, because we have not said before the Supreme Court also, we are willing to consider. We can only say that if the court directs us to consider. We are not saying.
No,
our-
then obviously you have to say something before the Honorable Supreme
What we
Court.
have said before the Supreme Court, we have said to the Supreme Court, what we have said, we have already filed an affidavit in Supreme Court, you can bring to your lordship that this is happened, you have been 16. If at all 16 would be taken into consideration, this would be the amount.
Whatever it may be.
And what I have said in the Supreme Court, we can also say it before lordship.
Yes, so far as the petitioner's case is considered,
Yes.
once you say that we are ready and willing.
No, what
also-
we have, as a matter of principle, we are cannot, as a government corporation, cannot say unless there is direction from the court that you.
No, that is how that we are passing this type of order.
Yes, your lordship can.
And we are keeping it if you say that it is.
And more so, there is another thing which is running against him in impeaching. That's a matter your lordship consider. What has happened, your lordship know? 7 crores he has received. All the person he has received as an arbitration award suppressed by him. All amount which is received on anywhere in insurance claim, we have the first charge. But instead of that, he never revealed to us. No matter when arbitration award and all that, at the stage of the execution, the insurance company informed us that there is some execution of this nature. We have
No, all those things can be brought on record, but the thing is that first of all, we have to know your willingness because
yes,
in view of this.
can direct a similar order
Yes.
as in Supreme Court. So
and
that
we-
the matter of the people will file an affidavit.
We'll keep obviously after
Yes,
the.
instead of all these are not relevant because these are Supreme
we can
Court.
keep-
His
we can-
prayer
The
is,
second order.
his prayer is only that MDF OTS 2007.
MDF OT.
Order
Malons,
2007.
That has been
we had
withdrawn.
applied- we had applied- Malons, let me, we had applied in 2007.
Right.
So we are obviously paying for 2007. Now let them come out.
You have no problem in 2016 then.
Malons, I'll have to take instruction. Let them come out
Yes,
with a
but-
mistake
Yeah, but-
that this is the amount we
Tell
have
your
to
lordship
pay.
that all this is instead of saying the last issue in the first when the same council was appearing in Supreme Court and as well in High Court. The matter is covered.
The matter is not covered, my lords. If your lordship sees the matter is not.
We are just
then
passing
I will
through.
argue.
We await the judgment.
Last occasion also my learned senior said this, that the matter is covered. Your lordships had asked me, Justice Sanjay Mishra had asked us, that you give a note as to how you say it is not covered and how. So,
No, you are
not
We'll not go into all these things. He is
They are not
conceding.
conceding.
2016 you are covered, then nothing like
my
that.
lords, let them offer a reasonable amount.
Whatever is.
Whatever is, if it can be worked out outside court, there is nothing like it, my lords. Otherwise, I'll have to apply
All right,
for my lords, my own
the
rights to be
petition
adjudicated.
has been filed
Lord, may I
by
refer to that other judgment also of the Supreme Court? What can be done that the matter has been
all right.
dismissed?
The writ petition has been filed by the petitioner, Susri Plastic Industries Private Limited.
Supreme Court
With a prayer or a direction to so and so at a lecture.
There are two orders. First order is confirm.
Mr. Padil and a senior advocate appearing for the opposite party number 2, typical, submits that
2007 scheme has been withdrawn.
Of course. At the outset submits that the 2007 scheme.
It's came in 2012, not actually 2000.
Scheme
was named.
2007 scheme was withdrawn by the EPICL. And 5 matters, including these 2 matters, which are listed today, were before this court, out of which
3 matters have been
3 matters have been disposed of. And in WPC number 5657 of 2013, which was filed by Messrs. Uburu One Industries Private Limited.
Suburban Industries.
This court has been pleased to hold which paragraph, Mr. Pading?
So they conclude that you
Paragraph 11 or what?
Sure.
Keep the judgment.
The publication of OTS case is denuded from superseding and withdrawing the suit.
While dismissing the writ petition, has been pleased to held as follows. Paragraph 11 ta quote kar diya, hai na? Stop. Mr. Pari further brought to the notice of this court that against the aforesaid judgment and order dated like the 8/10/2024, the writ petition WPC number 5657 of 2013 was disposed of. The petitioner approached the Honorable Supreme Court in SLP number, civil number so and so, and order dated 28/2025, the special petition was dismissed. The orders which are filed by the land senior advocate are taken on record. The land council senior advocate, however, submits
Another matter out of the Magnum. Magnum Fibers Private Limited. Similarly dismissed.
That similar order was passed by this court in WPC number 22753 of 2016, filed by Messrs. Magnum Fibers Private Limited and WPC number 513 of 2017, also filed by Magnum Polymers Private Limited, and all those.
Only one went through. One another still pending.
Magnum Fibers.
While
WPC number 22753 of 2016 was dismissed by this court by order dated 8/10/2024. This matter is pending or what? WPC number 513 of
Magnum is pending.
That is their file. The other one that been filed, I think, has not been listed. I'm not challenged, I'm not sure.
Whereas WPC number 513 of 2017 is sub judice before this court.
No, not, that has been disposed of. What has happened in Supreme Court?
No, but you have not given the operative part of the order. This is, some pages are missing.
Sorry.
Oh, last page. No, last page and so this order was passed, no? However, Mr. Pari submits that he is not aware whether the petitioner so in WPC number 513 of 2017 has approached the Honorable Supreme Court or not. But the petitioner in WPC number 22753 of 2016 has approached the Honorable Supreme Court in SLP number 4828 of 2015 and 25, and on 6/3/2025 the Honorable Supreme Court has requested has passed the following order. A पूरा entire court कर देंगे एक दुई dita court. Since
I have my contention may be also noted, my lords. What we are saying is factually these two cases are different from those three cases. That is why they were segregated, and we are squarely covered by Devi Dayal casting. And they applied. Those people had applied in 2016. We have applied in 2010. That may be.
Mr. Milan Kanungo Land Council submits that the factual scenario in the cases of in referred to above in the three writ petition are different.
That is why the application
different than the
that is why segregated.
No,
that's not segregated. I expect that from you.
I am also saying it's different. I haven't convinced you.
All right, we are just recording. We are not
submission.
We are just recording your submission. It is different, which is not, which is disputed by Mr. Pari, the Land and Senior Advocate appearing for the opposite party number.
The all legal issues are same.
Rather, he submits that the legal issues involved in all the five writ petitions are one and same. Stop. In view of the fact that the Supreme Court, Honorable Supreme Court is in session over the matter in SLP number so and so, we request Mr. Pari, Land Council appearing for the opposite party number 2 to ascertain whether there is any other way out for the petitioner to save his factory premises standing in the plot in question by paying some reasonable amount to the corporation.
As per 2016 scheme.
As per the 2016 scheme.
And this affidavit in question matter may come Supreme Court anytime. I will file within 1 month.
Asha, they put up this matter, this August message of the Land Council for the opposite party number 2 shall not only apprise us about the possibility of settlement between the parties, but also Land Council for both the parties. You are appearing, Mr. Kanungo, in that case, in that magnum, which is
appearing in not magnum. He is appearing in
Mr. Pari shall also apprise this court the development, if any, made in before the Honorable Supreme Court in the aforesaid SLP number 4828 of 2020.
Your Lordship can also direct it because that means to file an affidavit.
An affidavit to that effect shall be filed by the opposite party.
Devi Dayal, you are saying Devi Dayal. He says that
for any policy.
Mr. Swanso, Mr. Kanungo, Land Council appearing for the petitioner submits that the prayer of the petitioner is squarely covered by the decision
of Messrs. Devi Dayal.
Please give the reference so that we can mention it. By we are just mentioning this.
Your Lordship also can take into consideration that matter does not take into consideration. Earlier three husbands.
in the case of Messrs. Devidayal Casting Private Limited versus Haryana Financial Corporation and another reported in 2016 SCC online SC 1134. And he filed the citations which are taken on record. However, Mr. Padil and counsel submits that the appropriate petition was disposed of by this court. The case of Devidayal Casting Private Limited has already been taken.
Lord, you only add one sentence to question of payment of that. Incident due will matter be considered at the time.
Let us come next date.
I have just another premise.
Yes.
Not as per policy of 2016, any reasonable amount. Otherwise, I'll be restricted to 2016. I'll show your lordships I'm entitled to my release under 2000. If everything is settled, then
nothing else is possible.
No, just indicate any reason as per the term of the Supreme Court order. We'll file it back.
Because again, entering into the merits.
We should.
No, I will let the matter be heard. I will satisfy your lordship.
All right, this matter is to be listed along with WPC number 12938 of 2016. Hello? On the, you keep it into second week of August, so that.
In the meantime, at the Supreme Court order and affidavit also.
Right.
Devidayal is dealt with.
My lords, it is dealt with, but lordship is. My lords, just because a coordinate bench deals with a matter, my lords, another coordinate bench may differ with it.
No. If the factual
aspect is absolutely similar. That is why it has been segregated. Absolutely similar.
All right.
That is why I am pressing. Otherwise, my lords, I would have also conceded.
We are just coming with input.
Yes, my lords. Yes, sir.
Item 16.
From 16. For the petition, take 10 days time to file the rejoinder. Because on 19, I received the counter affidavit filed by the bank. So also the opposite party number 4 has also filed an additional counter. Rejoinder to that also necessary. 10 days time may be granted.
I am for the opposite party bank, my lord. In 2016 itself, my lord, all the, my lord, great chart, my notes of submission and also objection to the petition, everything is in record, my lord.
What is the prayer of the petitioner?
They'll challenge the action of the bank auctioning my land during pendence of the OTS application, which was filed pursuant to the.
No, that is not the prayer.
What happened thereafter? What happened?
That is not the prayer, my lord.
Now, your lordship, I am the auction purchaser since possessions 2016 was.
Why the matter is pending here?
Because he is challenging so far the auction part is concerned, their petition is there like.
No, why it is here? You have got the alternative remedy. You can go and approach. The third party right has already been created, and he is now the auction purchaser. And in view of the Bafna Motors, how this writ petition is maintainable here?
Yes, my lord. According to the prayer, my lord, this repetition is not at all maintainable, my lord.
Last the order dated 19/11/2000.
No, whatever has been done. But now in view of the Supreme Court latest decision, how we are again will adjourn and give you the for filing rejoinder.
Pursuant to the order passed by this honorable court in 2016, I have already deposited a sum of 15 lakhs.
Take that ground
That
in the
deposit is there.
take that ground before the DRT. So, take down.
Only one, dear Lordship, I have at least 1 week time.
No, sorry, it's already let. This writ petition has been filed by the petitioner, praying for such answers. It appears in view of the Bafna Motors versus relevant paragraph of the summary yesterday, the last paragraph is with the Chandrachud judgment. Petitioner is at liberty to seek appropriate remedy in accordance with law. Note the presence of C. Kosturi for the bank and Mr. Jena for the opposite party number 4. 4. All right. Disposed of.
Item 17.
Yes.
Section 17.
Next.
That is still there, my lord, the status
No.
That is not there.
2016 onwards, the status is operating unnecessary, non-maintainable.
I have already deposited 15 lakhs.
Take that ground in the before the DRT. Just yes, next.
The register action take back.
Yes, item number 17.
In person.
None appears. Stop. When the matter was taken off on 7/1/2023, on 23/1/2023, nobody appeared. The writ petition stands dismissed for non-prosecution. Yes.
Item 18.
This is an assigned matter. This is not in roster, it has been assigned.
Yes.
Not sure what has happened in this case. The petitioner started working under the opposite party number 3, who is the contractor, as a security guard on contractual basis in 2006. Thereafter, he worked till 2020, wherein, my lords, at the peak of COVID-19, he was illegally retrenched. Now, this position is, my lords, admitted by the opposite party number 3,
that no notice was served and 25F has not been followed. Thereafter, my lords, he approached the industrial tribunal claiming retrenchment compensation. Now, my lords, in the industrial tribunal, after taking into consideration all the facts, awarded 1 lakh rupees as retrenchment compensation. Now, my lords, in this petition, my only limited grievance is that retrenchment compensation be enhanced. Now, my lords, in total, 9 petitioners approached this honorable court as a batch matter. Out of those 9 matters, 5 writ petitions, already, my lords, the award has been increased to rupees 3 lakh from rupees 1 lakh.
Who has increased it?
Lordship, this honorable court. I am giving the certified copy just for the sign permission. This is the first matter.
Who is appearing for the management?
Notice.
Notice. Sushant Das.
Notice.
Lordship, notice is
Okay.
sufficient.
So-
Pending since.
Yes, right. Notice is
The order so that the
Notice is.
Sushant Das is the
No,
Sushant Das, right?
well, I am not there. Somebody else with the same name.
So do you know the Land and Council who is appearing for a
He actually, my senior, he usually appears on VC. So I have not met him personally in court, never.
We inform because without management it can't be.
You know the phone number?
No option.
Kahin कोटी लास्ट
member
सुशांत दास करो कितने नंबर पेज देख लो हम जो ऊपर ऊपर पेज देखो टोटल ब्रीफ रो पेज होची 103 से ऊपर गोटे लिखा है पेज नंबर अछि हम को पेज रे ता नंबर ता पाउजे वो ट्रैक कंसाइनमेंट जो तळे अछि सेटा लिखाई छी प्रत्युष महांती कोन लिखाई छी
Petition man, the absence of the neighbor service private limited.
Susan, right, we got it. That is page number 95 of the brief. So, Land and Council, please take down the mobile number.
I've taken.
Take him. So, just intimate him so that we can take up this matter. Acha, lekhondu. This order which you are telling, this is the that is also that SNEBA Security Service Private Limited.
Gotcha. Every fact, only the name of the petitioner is different. All the fact, everything is same.
This writ petition has been filed by Kamani the Sahoo, challenging the award passed by the Land and Presiding Officer Industrial Tribunal Bhubaneswar in ID case number 52 of 2022 in directing in holding that the petitioner is entitled to get a lump sum compensation of rupees 1 lakh in lieu of his reinstatement and back wages, and the opposite party number 3, Managing Director, SNEBA Security Services Private Limited, was directed to pay the awarded amount to the petitioner within a period of 2 months from the date of publication of the award in the official gazette. The Land Council for the petitioner submitted that similar situated employees of the opposite party number 3 challenged the similar award in which 1 lakh compensation was awarded, and this court has enhanced the award to rupees 3 lakhs. One of such case, please give it that, has been brought to the notice of this court, which was passed in the case of Aruna Naik versus State of Orissa in WPC number 41095 of 2023 by the order dated 27/6/2024. Stop. And the same is taken in the report.
Certificate. I will give.
अच्छा, आरो गोटे कॉपी करी हम दे दियंतु अबे ये आउ जदी अच्छी देई दियंतु एकाथरे से जदी आउ देबे से टाइप ऑर्डर सब गुडा को लिखि देबे गोटे ऑर्डर देइले लिख लेखन since Mr. Sushant Das, Land Council, is representing the opposite party number 3 and is not present in court today, the Land Council for the petitioner seeks for an adjournment to intimate Mr. Das about the listing of this matter next week. List this matter on 2nd of July 2025. See, we tell you what I think.
Item 19.
In this matter, I am appearing for opposite part number 2. It is the petition challenging the order of the OERC. That means that is regarding that challenging the OERC tariff regulation 2020 in respect of formula as received from GCB of coal and percentage of return of equity and PPA approval. PPA means power purchase agreement. The main dispute is that because the OPGC is in the second stage, there are 2 stages, stage 1, stage 2. So far the stage 1 generation is concerned, they supply to the, transmit to the outside the interstate as well as to the state. But so far the stage 2 is concerned, whatever generation, that is totally for the state. And state utilizes the GIDCO. So they supply, GIDCO supply to other distribution companies, not know the scheme of that. So now the dispute is between the two state utilities, that is OPGC and also GRIDCO. So that is why, as for the GRIDCO Board of Resolution, they have been moved to the government that please try to resolve this dispute. So that is why it has been moved to the government. If your lordship grant 4 weeks time, so that we can come back to your lordship. And this is the letter I have received, the copy of the letter.
Which for the petitioner?
Line for the petition.
For OP number 2. So that whatever development takes place, we can file a counter and also indicate to your lordship whatever the.
You are appealing for.
Otherwise also, my lord, it is barred by alternative remedy is also there. Because section 111, one can go against the order of the ORC to the after.
GPT resolved, nothing like that.
Yeah.
I have something to say on that.
We don't have a copy of the letter. Letter, got a copy. We don't have a copy. We can give you, but up to now, I know that you are on the same plan. Oh, you are some okay.
It is a GRIDCO's letter to the Additional Secretary of the
Yes, Energy
Department of Energy Department.
My lord, second paragraph is relevant.
Convening a joint meeting between among OPGC is
and
the petitioner and GRIDCO at the government level to facilitate any progress has been made in the meantime.
Recently it has been.
Because I wasn't even aware of this letter.
Yeah.
And I wasn't even aware of this letter. And I
Uh-huh.
think the characterization of the problem before my lords is slightly off the mark. If I might clarify that. my lord.
No, you just go through the letter
Yes,
and
I will. But
If the
Take-
government
take-
level is something is to be worked out,
I'm
why
owned by
not?
the government. I'm owned by the government.
It's all right, but
Because-
see, Gridco and you, whatever disputes are there, it will be.
There are disputes between us and Gridco. So essentially,
Both are-
just one second. If my
Both are under the umbrella of the government.
Yes. There are no disputes. There is a contract between me and Gridco, where I have been set up by the state government of Odisha, as has Gridco. I generate power. Whatever power I generate, I sell under that contract to Gridco. All of that, the Honorable Commission had approved in 4th April 2012. When I go to them for another stage of development of my project, I have every time there is a fresh stage, I have to go to them for approval, the Learned Commission. This time, again, Gridco goes because it is the agency that is a licensee of the commission and asks for approval for power procurement from me. This time, the commission says no and doesn't give any reasons. Then the matter comes before my lord. My lord, the Honorable Justice Mishra was also member of that bench that passed an order in 23 which said, yes, we can see no reasons why there should be a volte-face from the 4th April 2012 order. So the matter was sent back to the Learned Commission. This time again, Gridco appears, OPGC appears, and we make our submissions which are completely aligned because both of us are contracting parties. Both of us want that power procurement process to move forward and for approval to come. However, the Commission again rejects granting approval, not just for these two units that are the fresh power purchase agreement, but also the original one that they'd given approval in 2012. So I then have come before my lords again, saying, look, once again, we're in the same
But
position.
it's all right, everything is all right, but why are
So
you
there is
ever,
no dispute
why are
between
you
the-
ever to?
No, we're not averse at
No,
all.
he is not aware of
Yeah,
it.
no,
I'm
settlement.
not aware of it.
Let it go, the settlement.
The problem is that there is no dispute. So anyway, we'll go and clarify to
And you just surprise us.
Energy
Here
department.
for the OES.
Hmm.
What has happened? Earlier, you also found that there is no reason for the support.
OERC.
Yes, ma'am.
Yes.
In support of the order. Therefore, the matter was remitted. The question is that if there would be 50% supply to outside the state, then it is the Central Commission who will fix up the tariff. Now, because of the change in the situation, when Gridco gets everything 100%, then it is the state commission who has to do it, fix the tariff as per the state rule. But interestingly, they say that we will continue to be fixed at that central tariff, which the state commission doesn't have the power even. They could have approached the central commission, and otherwise, the order which is the statutory order and the rate of statutory is here before my lords. We find that it's an appealable order, the order which is in challenge. Earlier, your lordship found, observed in the order also, that there is an alternative remedy.
What is the
But because
what is that
there was
order?
no reason at all.
What is the section you say alternative remedy is there?
111.
111.
111.
Your lordship last time reminded because who will pull apply?
Yes.
Because
People
some
applied and the
points
reason was
are
not-
not considered.
The reason was not there.
111 of
Electricity Act,
Act.
Electricity Act.
electricity.
I'm on the Viries Act. So the Honorable Tribunal under the appellate powers doesn't have the power
No,
to.
you are not challenging the varies.
I am. I'm challenging the Viries of both the.
So you
orders.
say only the,
And for your lordship-
under clause 1 of,
Some of the
And
provisions.
your lordship's information is that,
My prayers, my lords will kindly have.
98.
for your lordship's information is that, in fact, as against stage one, for tariff fixation, that was already, decision was there by the commission, and then already the appellate authority is in decision of the matter in respect of the same point involved.
All right. The Land Council for the senior advocate appearing for the opposite party number 2, Gridco, submits that against the impugned order passed under annexure, which is the impugned order?
Sure.
Annexure
105, Annexure 1.
Annexure 1. Order dated so-and-so, dated so-and-so, passed by so-and-so. Though alternative remedy is available under section 111 of the Electricity Act 2003.
My lord, I'm also challenging the regulation.
All right.
That's the second.
Just a minute, it is a commission.
Yes.
But a development has taken place in the meantime, and the GRIDCO has written a letter to the government for amicable resolution of the matter between the parties and to convene a joint meeting among OPGC and GRIDCO at the government level to facilitate dispute resolution and unwarranted litigation. The letter dated 31/5/2015 is produced before us, which is taken on record. The Land Council for the petitioner submits that he is not aware.
I've given a copy now.
About such a letter stop. A copy of the letter has been handed over to the Land Council for the petitioner in court today. You have already.
Yes.
Mr. Mahantil and senior advocate submits that the matter may be taken up after 4 weeks so that he'll apprise the scope development, if any, made towards and the outcome of the proposed joint meeting to be held to facilitate the dispute between the parties. Does this matter? So this letter is taken up.
You also may kindly record that the matter is within the exclusive jurisdiction of the commission.
But he challenging, I don't know whether seriously or otherwise.
I'm saying
to maintain the writ, he might have challenged his violence.
may kindly note my contention that it's a exclusive jurisdiction of the commission.
All right, let it come after 4 weeks. We'll see that.
My submission can you also may kindly record because
all right. Yes. Next.
My lord, just one clarification.
That may cause prejudice, my lord. Your lordship.
Yes,
I don't
item
say
number,
that your lordship should
Item
make any
20.
observation.
item number 20.
Just my submission. If
Oh,
your
we
lordship
will see that in the next.
My lord, just one thing. My lord has recorded my submission that I'm contesting the order pass. My lord will just say inter alia there. Because I'm also
Inter alia according to order dated so and so inter alia with other players. Yes.
Secondly, my lord,
Item
the counter has already been filed by opposite party number 2. Now,
Alright.
opposite party number 2 is GRIDCO. Is GRIDCO, but the state government has filed as opposite party 2. So if my lords will just clarify that, otherwise the matter will get delayed again because there'll be some confusion and
See
will
next
not
time.
file it.
We'll see the next time. Yes.
Lord,
Item number
save
20.
me from embarrassment, your lordship may kindly record. Just a
Item
line.
number 20. Yes. Please.
Just a line, my lord. I don't think.
Yes. Item number 20.
I pray, madam, time to file the agenda. That has not been filed.
Land Council for the Mr. Maharana, Land Council appearing for the Union of India, submits that he has received the counter affidavit filed by the opposite party and he may be given some time to file the rejoinder affidavit. Is this matter? कितने दौर का time कौन दो? 3 weeks time कर दूँ तो does this matter? What date दे दूँ after 3 weeks?
Item 21.
21, my lord. I'm for the bank here. I filed my reply. Here, what had been sought for in the writ application is twofold, my lord. Your lordship knows, under section 32 of the Securitization Act, once it is issued, a reply, statutory reply has to be given under section 13, clause 3, subclause A, within a specific period. His case was that I have not given any reply and I want a list of documents. In my counter affidavit, my lord, I have filed his reply under 13(3)(a), where he has gone to the merits of the case saying that the mortgage documents are all fraudulent and fabricated. We have given.
He has already filed the reply.
Yes, kindly see, my lord.
No. You are making a wrong statement before this court. File an affidavit that you want time to file your objection. But by that date, when you file this expedition, if the 13th, The objection has been filed. He is having a copy of the same.
That is part of the record in the counter affidavit.
Yes,
And
sir.
the conducting also the petitioner gone through surgery. That way I'm therefore taking action.
But my only prayer is 13-4 has been issued. At this stage, he has to now approach the debts recovery tribunal
He is
17 now.
taking
under section 17. So there is no adjudication on merits by your lordship.
the
Gopadas. July 15 ଆଡକୁ ଆସୁ ତାର କ'ଣ operation
prayer is made on behalf of the, what is your name?
Priyadarshi Swagat Malay.
Lakshmi also submits on behalf of Mr. Gopavandhu Sahu that the 11th Council has undergone surgery and therefore the matter may be adjourned for 3 weeks. What is this matter? July
15 ପରେ ଆଜ୍ଞା ଆସୁ so that
21 तारीख period.
ଆଜ୍ଞା your lordship can dispose.
Yes. Mr. Subrat Mishra and counsel for the
State Bank of
State Bank of India is present for. Yes.
obliged.
It is 7/2025. Yes, next.
Item 22.
Item 22, ma'am, I think so.
Yeah.
In this case, my lord, the petitioner has challenged the order of the learned tribunal. Yeah, that is Central Administrative Tribunal, OA number 30 of 2011. Yeah.
Which for the other side?
Melo.
Yeah.
In this case, my lord, the opposite party was initially appointed as a coast guard, coast guard, in the scale of 4,500 to 7,000 under DRM, Division Railway Manager Sambalpur, and was posted at Titlaka. And subsequently, he was empaneled for the post of traffic apprentice through General Department Competitive Examination, and was under initial training, and was again joined in the post of and he was posted at traffic apprentice in the year 2008, man. And there was a RB Railway Board circular, that is 132 of 2006, that clarifies that he is not eligible for 30% of earning allowances element. And the learned tribunal has in Annexure 1 has held that, my lord, may I come to para 8 of the in order.
Yes.
In view of the aforesaid observation of the Honorable High Court of Orissa and the fact that the applicant was allowed the pay in promotional post with effect from 1st of August 2005 for the purpose of increments, which can only be worked out after fixing the pay. The RB number 132 of 2006, which has come much after 2005, having not retrospective implications, rather with emphasis that past cases should not be reopened, the impugned order of rejection dated 4/1/2011 is hereby quashed. The respondents are directed to fix the pay of the applicant with a pay scale of rupees 5,500 to 9,000 in terms of RB work prior to RB 132 of 2006 and pay the applicant the differential amount after refixation of his pay by adding 30% pay element. The entire exercise shall be completed within a period of 180 days from the date of receipt of a copy of this order. My lord, this RB 132 of 2006, it is clarificatory in nature. And when it is a circular is a clarificatory.
But the High Court, but the High Court has already clarified that it pays para 7, read it.
No.
Para 7 of the change judgment.
No.
Read para 7.
That in compliance with the
As noted above, para 7 of the impugned order.
As noted above, the matter was dismissed by this tribunal, while order dated 15/10/2014, which order was challenged by the applicant before the Honorable High Court of Orissa in WPC number 21197 of 2014, and the Honorable High Court of Orissa, while remitting the matter back to this tribunal by quashing the order of this tribunal dated 15/10/2014, was pleased to observe as under.
You read it now.
Mr. D. Gochar, learned Central Government Counsel, appearing for the opposite parties, relying upon the counter affidavit, stated that the tribunal is well justified in passing the order impugned, which does not warrant any interference of this court at this stage. It is further contended that the scale of pay of the petitioner has been fixed on his appointment to working force,
Deputy SS.
Deputy SS, considering
SS कौन है? Deputy SS कौन?
Station Superintendent Mela. Station Superintendent.
Considering notional pay to rupees 5,500 with effect from 1/8/2005 under RP rules 1997, getting pay fixation notionally with effect from 1st January 2006 as per RP rules 2008, and allowing onwards notional increments as per extant rules applicable for direct recruitees. Therefore, it is contended that this court should not interfere with the order passed by the tribunal. Having heard learned counsel for the parties and after going through the record, this court finds that the petitioner claimed for fixation of his scale of pay, and as such, it is contended that the reliance placed on RB 132 of 2006, issued by the East Coast Railway Establishment, has no application.
To the present case.
And therefore, the contention raised by the learned counsel for the opposite parties cannot sustain in the
Yes.
law. Right.
You place again the reliance on this while passing the impugned order.
Because, my lord, this order is clarificative.
Therefore, the tribunal has said that you could not have placed reliance on 2006 this thing. What is wrong?
We have in this petition, my lord, we have also relied upon annexure 6 and 7. My lord. That is RB. Annexure 7 and 8, page 73 and 74. My lord, in the writ petition, I have already stated, submitted. My lord, para 8 of the writ petition. Sorry, ma'am, para 14. Para 14 of the page 14. Maybe.
Yes.
Yes, it is humbly submitted that RB number 132 of 2006 dated 59/2006 is a clarification with reference to Northern Railways. Letter number so and so dated 1st April 2004. It is established principle that he was selected for the post of traffic apprentice in the year 2005. On completion of his training, he joined the work post with effect from 22nd of May 2008. After joining the workforce, his pay is to be fixed with effect the date of death.
You come to the counter affidavit, which has been filed, and come to the paragraph number 8, page number, say, page 81 over. Internal page which is 6 of the counter affidavit. Paragraph 8 question. Counter affidavit. Page 81. Sir, counter affidavit or page 6 of running page which is 81. Milda Seda.
That para 8 months. That as the
Just a minute, just wait, counter affidavit.
Yes.
Paragraph number 8.
Yes, really.
Para 8 months. That as the writ petitioners have denied 30% pay elements by order dated 11/5/2010 and 4/1/2011 by applying RB number 132 of 2006 retrospectively, the rejection order becomes known as in the view of order dated 26/10/2022 passed by the Honorable Court in WPC number 21198 of 2014. Hence, the learned tribunal has rightly caused the order of rejection dated 11/5/2010 and 4/1/2011 and directed to grant 30% of pay elements.
So,
How many times you will re-agitate? First you tribunal, thereafter High Court, again remanded, again the same order, again you are challenging the same issue.
this particular contention was raised and the Honorable High Court has disallowed it, that now we could have challenged it before the Honorable Supreme Court. Again, you are re-agitating the same point, which has already been decided by this court.
Oh, my lord, Annexure 7 page.
Yes.
And that is establishment serial number 4591. Here, my lord, the counting of training period for the purpose of drawing increments. That paramount. The understanding is directed to say that under FR 26 only duty in a post on time still counts for increments in that stage. As per FR 96AI, the service as probationer information. As such, the training period during which the government servant is not remunerated in the scale of pay attached to the post cannot be treated as a duty matter.
You are re-agitating entire issue once again.
My lord, that was
That's
clarity. So, my lord, that retrospectively it was held, ma'am. So that was a clarification.
Retrospective, earlier litigation, it says that it will not be retrospective. Again, you are arguing the same thing.
That is a stand.
You should have challenged that order, earlier order. If you are so aggrieved.
May I pray, my lord? The lordship can turn to page 28. Internal page 6 of one tribunal's order, my lord. The issue not decided before this order for the first time. The circular was under challenge. The lordship can give answer the order of Honorable High Court of Allahabad, my lord.
28.
Man, Lord Tribunal has taken note of that. High Court in case of Union of India versus Subhasis Haldar and another civil means
page 14
page 28, my lord. Read page number.
28 the order करना.
Subhasis Haldar.
Subhasis.
22.
हाँ. Yes.
That issue. So RB was under challenge. Where the Honorable High Court of Allahabad has observed that I am passing on my lord that order. Let's continue. Okay. The order for refixation of pay after deducting the running allowance was passed on 26/2/2004.
Where are you reading?
Last page, my lord. I guess. Pura last page, that is last para of order of Honorable High Court of Allahabad.
The petitioner was appointed on.
Again.
The order, yes. The order.
The order for refixation of pay after deducting running allowance was passed on 26/2/2004. The circular dated 15/9/2006, that is my RB number 132/2006, is dated 15/9/2006. Specifically provide that it will not have a retrospective effect. So it could not be placed into service for deducted running allowance as element for fixing the pay and to direct recovery of the excess amount. So well, this circular is not having retrospective effect, and admittedly my pay fixed with effect from 1/8/2005, my lord.
That is their clear one.
My lord. And that is the admitted fact of the counter, page 4, my lord, para 3. My learned friend has admitted in the counter in the present read petition, my lord. The lord will give a glance to that.
Para?
Page 4, my lord. Page 4 of the
counter affidavit.
Read petition, my lord.
Or read petition.
Again. Last 7 lines, my lord. on his joining to the post of deputy station superintendent through GDC on a regular basis.
Paragraph 4 wrong.
Page 4, madam.
Page, what's your page 4? Page 4 टा होची paragraph number 3 होगा ना?
3 the continuance, madam.
हाँ.
Last 8 line.
On his join.
On his joining to the post of deputy station superintendent through GDC on a regular basis, his pay has been fixed in pre-rebate scale of rupees 5,500 to 9,000 with effect from 1/8/2005. So if my pay fixed on that day, as on that day, there was no concept of issuance RB number 132 of 2006. So the RB which was vogue at that point of time, that will govern my case. That was my case, and that was observed my lords in the previous writ petition, and relying upon that, the long term has passed the order. Now is present impugned in this writ petition. Okay.
Order will just put.
Oblige.
Counsel for non-litigation, Mr. Gushay, counsel, Mr. Rautre, then counsel appearing for counsel. Order is there.
Oblige.
The doctor's marriage of the present appellant will be held on Memo 29/6/25. So pray for him.
My case matter to the criminal appeal will allow lordship directed matter to be listed before vacation. And then in after vacation, accident the matter.
What purpose? Hearing?
My lord?
Hearing or bail matter?
No, bail matter.
Give it matter. So, Mr. Tripathi, you have received the copy of the order dated 18/6/25?
Yes, sir.
And Mr. Mulia? Whether they are present?
They're present, madam.
And Mr. Das, Dilip Kumar Das.
Yes, my lord.
हाँ आपण तांको पाखरे रुहंतु तांको बुझेइबे जहा होची जहा दरकार कहबे हला आ तांको कि अछंदी तां चेयर दियंतु से माने बसिया पई से माने बसंतु वकील हो बसंतु हला हाँ जस्ट Media it is MULIA তো আপনার নাম সারনেমটা আপনার MULIA তো ঠিক তো সত্য রঞ্জন মুলিয়া ঠিক না Mr. Tripathi, it is EEBASHIS, ठीक है? तो हाइट तो फिर ना तो इधर रख दिया Just let us recapitulate which what we have. You have mentioned it in the written statement, but let us come to the charges framed. That is page number 17 and 18. Volume 1. That is volume 1. So, 449 by 34, 363 by 34, 364 by 34, 394 by 34, 302 by 34, 201 by 34, 25 1A and 27 1 answer. Now, judgment is in the second volume, huh? Second volume. So, tell us which were the charges which have been you have been acquitted. 217. Just page tag
217 meter. Second volume.
217 second volume.
Actually, it pays 218.
हाँ नहीं acquittal जो ହେଇଛି ସେଇ particular part को पढ़े आछंती ଏଇ charge ଗୁଡାକ acquittal ହେଲା ଏଇ ଗୁଡାକ conviction ହେଲା
Page 242 meter.
242. Paragraph number 11.
Paragraph number 11.
So acquittal is 363 by 34 acquitted.
394. 394 and
394 acquitted. Then 25 and 27 arms are acquitted. 364 by 34 convicted. 302 by 34 convicted. 201 by 34 convicted. 449 no finding.
No findings.
Okay. It's a case of triple murder. So what are the name of the deceased?
Viranchi Tarini.
Just one by one.
Viranchi
Naik. Viranchi Naik. Tarini Naik. Yes. Mabal Naik. Ekolabya Naik.
minus only.
Nobba alias Ekolabya Naik. They are related to each other.
Yes, ma'am. Father.
Father, mother and minor sub-miller.
So Biranchi is the father. Tarini is the wife of Biranchi. The mother. This is a minor child.
Yes.
What was his age at the time of occurrence?
8 years. 8 years.
8 years.
Yes.
Okay. Date of occurrence you have?
Date of occurrence, madam, on 9/10/2017.
9/10/2017.
At about 8 p.m. to 10/10/2000 at 8 a.m.
TO2 10/10/2017
at 8 a.m.
अच्छा 8. No eyewitness to the occurrence.
No,
So, as we noted down the other day, both of you submitted that these are the circumstances. Let us take note of it once again. Circumstances is the first circumstance is last seen.
yes.
And the only witness who has stated about it is PW 37.
37.
Right? Number 2,
DNA report.
you said about the seizure list exhibit 1, it account seizure list of what?
Let's put the wearing appeal of the appellant number.
Acha. Seizure list exhibit 1. It is seizure of
Wearing appeal of appellant number 2.
wearing apparel of this one. So, appellant से ले number 1 के
Prakash Behera.
Babuli alias Prakash.
Prakash Behera na?
Behera.
Alias Babuli.
Babuli.
Yes, sir.
Prakash Behera alias Babuli. Number 2?
Nanda Kishore Sethi.
Alias Ranga.
Nanda Kishore Sethi.
Again.
Alias
Ranga.
Ranjia.
Ranja. RANJ.
Ranja. Okay. So, you mean to say that this seizure list exhibit 1 is the seizure of wearing apparels of appellant number 2.
Yes.
What are those wearing apparels?
One black color full pant.
Memo 23.
Is
Black color full pant. Memo 23. And
seizure list is exit 1/2.
नहीं सी गुट्टी है अच्छा सीजर लिस्ट exhibit
1/2.
Okay. Then you said that there are 2 seizure lists so far as apparent number 1 is concerned, right? So, seizure list exhibit 19. What is that seizure list?
One Fatari and one Gamuch, Bloster Gamuch.
Gamucha
Seizure of Gamucha, tar MO mark ହେଇଛି?
MO7.
Memo 6 and 7.
Gamchata?
Fatari was
Gamucha
No,
7.
Gamchata কোন?
7.
MO7. And Kotari.
MO6.
Memo 6.
এটা কি জগৎ হল কাঠু জগৎ হল
Appellant number 1.
He led the police or?
Yes, he did.
Sure.
Statement taken on decision of everything, sir.
Seized are the instance of operand number 1 under section 27 of the Evidence Act. Okay.
Statement was executed.
Just 1 minute, we left it something. ये जो सीजर लिस्ट एग्जिबिट 1 टा कहले आपण तारो विटनेस किए?
Witness in my hearing.
Witness who are the witnesses?
People 1 and 2.
ये जो exhibit 1 रो
Memo 23 रो
Memo 23 रो जो
PW
exhibit 1 by 2
PW 1, 2 and 41.
आयु टा को भी मिसेई कहले
1 to 41. PW 1,
PW 1
2 and 41.
2 41 right now पळे आसंती जो गामुछा और कटारी रो गोटे सीजर लिस्ट से सीजर लिस्ट नंबर होची exhibit 90 सेटार witnesses किए
1135.
PW 11 and 35.
PW 11 and PW 35 आयु
PW 41.
say 41 तापरे आउ गोटे सीजर लिस्ट कथा कहिथिले exhibit 21 कहिथिले जो
Hearing appeals.
सीजर लिस्ट exhibit 21 what is the seizure list?
Wearing appeals of the appellant number 1.
Full set.
Where
Full set.
Yes, sir. Cement color full set and blue color jean pant.
of appellant number 1
Yes.
what are those full shirt what
One is cement color full set. Second is a blue color jean pant.
full shirt and jean pant full shirt टा केते मार्क हिची
Memo 1.
Memo 1 and jean pant हला
Memo 2.
Memo 2 अच्छा यार विटनेस किए कौन
PW 15.
PW 15
And one Suramani Pradhan. But not examined.
not exam छाड़ दिया आयु
41.
41 so these are the 3 seizure lists which are relevant so far as the appellants are concerned ये गला गोटे तापरे next circumstance आपण कहिथिले DNA test report
Yes. Exhibit 59.
DNA test report exhibit 59
Page 349 of
এটা volume 2 रे
349.
2 रे page
349.
349 रे रहिଛି এটা কি proof কলা
Scientific officer PW 49.
Take proof on that.
scientific officer examination
Proved by the IO madam. PW 41.
এটা ত্রিপাঠী
Madam.
scientific officer examination দিবি সেদিন আমি নোট করছিল PW
Only 41.
40 ବୋଲି নোট করছিল
40, yeah.
and PW 40 I think he is not the scientific officer
Who is 40?
So kindly turn to volume 1, page 182.
yes he is the scientific officer Mr.
Yes.
Scientific smile.
He has not proved that exhibit 40 so the IO has proved
41.
हाँ ठीक है जी हमें the exhibit 59 टा जोटा DNA test report that has been proved by PW PW 41
Yes, ma'am.
PW 41 is the IO
Yes, sir.
so PW 40 has not proved it okay now the next one is as you said there is a motive behind the commission of crime and that motive part Mr. Tripathi said on that day deposed to by PW 36
Another exhibit is left out. Another exhibit is left out.
ওটা কোন
Exhibit 4.
কোন সেটা
seizure of wiring apparatus. On production by accused Nanda Kishore Shetty.
हाँ सेटा कितने नंबर
267 at page 267.
just a minute. Okay, 8 are put up the comment. Sorry, এটা হচ্ছে আপনার নম্বর 2 তো
Nanda Kishore Shetty.
हाँ আপনার নম্বর 2 তো নন্দ কিশোর সেটি सीजर लिस्ट वाला एग्जिबिट कितने हैं
4. Exhibit 4.
एग्जिबिट 4 another सीजर लिस्ट कौन सी राशि जबत ହେଇଥିଲା
The motorcycle and one half shirt.
ଧଳା ରଙ୍ଗର half shirt.
White color half shirt and one Honda.
Honda
motorcycle.
motorcycle ଆଉ ଗୋଟେ ହଉଛି half shirt अच्छा
PW 4.
यार विटनेस किए PW
410.
Notandar Naik.
PW 4 PW 10 ଆଉ IO PW 41
MO 20.
half shirt টা হচ্ছে MO 24 XXIV Mr. Tripathi and Mr. Mulia, these are the total circumstances. Okay. Now, we are going on that day circumstance wise. So I think you have placed the evidence of PW 37 on that. So passing. Please come to the PW 37.
Page 174.
PW 37. Page 174. अच्छा ଏଇଟା ଆମେ ଯାହା ଲେଖିଥିଲୁ ଯେ ଯଦିଓ occurrence took place on 9th and 10th, in between 9th and 10th to 10:10, the 161 statement of PW 37 recorded on 17/11 2017. ठीक था अच्छा please press it once again. He is a grocery shop owner.
On 2017, I was running a grocery shop at Thakurgarh near a foreign liquor shop on 9/10/2017, Monday, at about 9 p.m. to 9:30 p.m. These two accused persons, along with another named Viranchi, had come to the counter of foreign liquor shop of Thakurgarh. They have purchased liquor from the foreign liquor shop and thereafter came to my shop to purchase water pouch, the use and throw glass and mixture. They consumed liquor in front of me. They stayed at my shop for about 10 to 12 minutes. At that time, they were asking to Viranchi to go to Kora Pattanalai to see the melody. As the melody is not good at the Thakurgarh. In back in my Thakurgarh, the melody bhala good. Then all the three persons moved with a red color motorcycle. On the next day, there was a viral news through mobile phone that Viranchi has been murdered. I have seen the said video sitting at my shop, and after 2 days of the incident, I found image of these two accused persons whose news was viral through the mobile phone. I could identify the accused person along with the deceased from the viral video
as they had come to my shop on 9/10/2017, Monday, at about 9 p.m. to 9:30 p.m. They had decided to go Ola Pottonari to see the Melody, and on the way, performed as this found. Today, these accused persons are standing in the dock. Witness identified the accused person. I was examined by the police in connection with this case. So PW 37, he was examined in court on 08/12/2023. So what he precisely stated that the two appellants along with the deceased, they first came to the foreign liquor shop, and the day was 9/7/2017. Time was 9 p.m. to 9:30 p.m. Then they purchased liquor. Then they came to the house of this PW 37. Shop of this petition, and purchased something, then consumed liquor, and the total period of stay is for 10 to 12 minutes. Then they asked the deceased to go to see a Melody at Kola Pottonalai. Acha. This witness has stated, and on the next day, he said about the viral video and came to know that Viranchi has been murdered, and image of the two appellants were also made viral through mobile phone, and he could identify that this is the deceased who had come, and along with these two appellants. Okay. Now, what have you elicited in the cross-examination? Please read the cross-examination. I cannot say how many customers had visited my grocery shop on 9/10/2017 from morning to night. The accused person had purchased artificial water pouch, use and throw glass, and mixture was ₹20 to 30. I was knowing only Prakash Behra, that Babuli, prior to this.
I was knowing only Prakash Behra.
Yes, ma'am.
Appellant
Number 1. So prior to this case, as he had a purchase of furniture shop at Thakurgarh market. And I had no prior acquaintance.
I had no prior acquaintance with the other accused.
On the accused. Yes. Police had not seized any document from me regarding my grocery shop, which is situated near to the foreign liquor counter. I had no prior acquaintance with the deceased Viranchi. I had no prior acquaintance with the deceased Viranchi.
This you read in the first paragraph of the chief. In the chief, he has taken the name of Viranchi.
The appellant also my name of this.
In the first paragraph, it said in chief, these two accused persons along with another, namely Viranchi, had come. That means he knew Viranchi.
In cross,
Chief, he says that he knew the Viranchi, and whereas in the cross, he says that I had no prior acquaintance.
Yes. I cannot say the registration number of the motorcycle used by the accused person, but it was a vehicle of Hero Honda company. I do not remember the name of the person from whose mobile phone I could see the viral video of these two accused persons. I cannot say the company brand of the liquor to which these two accused persons have purchased from the foreign liquor shop. Ranjan Prasad Singh is the owner of foreign liquor shop. I did not refuse the accused person to consume liquor in front of my shop. I was examined by the police after 1 month of the occurrence. I did the fact that I was being biased by the police. So what is important is that on the very next day, he saw the viral news and came to know that a person who had come to his shop along with two other persons and took water pouch and use and throw glass and mixture and stayed there for 10 to 12 minutes, was found murdered. And in spite of that, even though the investigation has commenced, police was examining the witness. This witness did not volunteer to give his statement, and his statement was recorded 1 month after the occurrence. And exact date, if we see the 161 statement, it is 8/12/2023. No, it is sorry. It is 17/11/2017. So he's right, it is more than 1 month. So,
The evidence is
just a minute, just a minute. When the appellants were arrested, see the evidence of the investigating
12/10/2017 at 3 p.m.
12/10/2017
At 3 p.m.
at 3 p.m. And they were forwarded to court, right?
Arrest memo is exhibit 2 and 3.
Acha, whether that viral news which was stated to have been seen by this PW 37 that was in the mobile phone, whether that was proved.
No.
So out of these 3 persons, one is the deceased, 2 are the appellants. Ajit appears he did not know the deceased beforehand. He did not know the appellant number 2. And he only knew the appellant number 1. So
The evidence different from his statement recorded on 161 statement.
161 CRPC statement indicates as if he does not know anyone out of the 3.
But in cross-examination, that question was not put to the
we are mentioning it. No question put in cross-examination. Acha. So far as this appellant number 2 is concerned, admittedly, if he had no prior acquaintance and saw him for the first time on the date of occurrence, then a test identification parade was required to be conducted. That has not been conducted. Has it been conducted?
No. Okay.
So far as appellant number 2 is concerned. Similarly, so far as the deceased is concerned, photo identification could have been made যে এই 8-10টা ফটো ଦେଖ ତା ଦେହରୁ ବାଛ ତମ ହୋଟେଲ କୁ ବା ତମ ଦୋକାନକୁ କିଏ ଆସିଥିଲା, that has also not been done. Photo identification of deceased not done. What was the source of light in his cabin in that night when he saw the three persons for 10 to 12 minutes? Is there any evidence? No. Any explanation he has given as to why he has made a belated disclosure before the police about 1 month after the occurrence? No. So if appellant number 2 is concerned, if we see the evidence of this PW 37, so according to him, he saw appellant number 2 for the first time in that night for about 10 to 12 minutes in his grocery shop. No TI parrot. No. And he was identified in court
For 5 years.
after 5 years. 5 or 6 years? No, it is 6 years. It is because the occurrence took, he deposed in court on 8 December 23. And the occurrence took place on 9/10/2017. So it was after 6 years.
All these evidences are vis-a-vis the murder of Viranchi only. How you connect the other two homicide with these evidences?
There was no last scene with those two deceased.
Nothing is there with them.
Only with Biranchi last scene is there. For the other two deceased, is there any evidence of last scene?
The Toroni and minor
That minor son.
There is none.
So
only will scientific report.
no, we will come to that. We are
Only the DNA test. Except
we
that
are on a point about last scene. So no last scene evidence
vis-a-vis the other two deceased.
vis-a-vis the two deceased.
Tarini and Ekalabi.
Montana Toroni.
Toroni and Ekalabi.
Toroni Behera na?
Naik.
Beher Naik.
Naik.
Viranchi Naik.
Tarani Naik and Ekalabu.
Toroni Naik and Ekalabu Naik.
Ekalabu Naik.
So, Mr. Tripathi, you are to answer so far as this particular circumstantial evidence is concerned, that no doubt the defense has not proved any kind of hostility between PW 37 and the appellants, that there was any inimical relations for deposing falsehood. But this man who was having a grocery shop claimed to have seen this appellants in the company of one of the deceased, whose name is Biranshi, right? ରାତି 9ଟାରୁ 9:30 ଭିତରେ 10 ରୁ 12 ମିନିଟ ସମୟ ସେମାନେ ମଦ କିଣିକିନି ଆଉ ଗୋଟେ ଦୋକାନରୁ ଆସିଲେ, ତାହା ଦୋକାନ ସାମ୍ନାରେ ତ ଦୋକାନରୁ ବସିକିନି ସେ ପାଉଚ୍ ନେଲେ, ଆଉ ୟୁଜ୍ ଆଣ୍ଡ ଥ୍ରୋ ଗ୍ଲାସ୍ ନେଲେ, ଆଉ କଣ ନେଲେ, ମିକ୍ସଚର ନେଲେ। 10 ମିନିଟ 15 ମିନିଟ ବା 12 ମିନିଟ ଖାଇଲା ପରେ ସେମାନେ ମେଲୋଡି ଦେଖିବାକୁ ଆଉ ଗୋଟେ ଜାଗାକୁ ପଳେଇ ଯାଇଛନ୍ତି। ତ ସେତିକି ହିଁ ଅପରଚ୍ୟୁନିଟି ଅଛି PW 37 ର 2 ଜଣ ଆପେଲାଣ୍ଟ କୁ ମାର୍କ କରିବାକୁ ପ୍ଲସ୍ ଡିସିଜ୍ କୁ ମାର୍କ କରିବାକୁ, ରାଇଟ୍? ତା ପରଦିନ ସେ କହୁଛି ଯେ ଭିଡିଓରେ ମୁଁ ଦେଖିଲି ଯେ ଗୋଟେ ମର୍ଡର ହେଇଛି, ଆଉ ଯୋଉ ଲୋକଟା ମର୍ଡର ହେଇଛି ମୁଁ ଦେଖିଲି ସେ ଲୋକଟା ମୋ ଦୋକାନକୁ ଆସିଥିଲା ଏବଂ ଯାହାଙ୍କ ସାଙ୍ଗରେ ଆସିଥିଲା ମଧ୍ୟ ତାଙ୍କର ଭିଡିଓରେ ସେଟା ମଧ୍ୟ ଦେଖାଉଛି। ସେଇ 3 ଜଣଙ୍କ ଭିତରୁ ସିଏ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ ଆଣିଛନ୍ତି he had got no previous acquaintance with appellant number 2, that is Nanda Kishore Sethi alias Ranja. He had no previous acquaintance with deceased Biranshi. ठीक था? He said that I had only acquaintance with appellant number 1, that is Prakash Behra alias Babuli. ତେଣୁ ପ୍ରଶ୍ନ ଉଠୁଛି ଯେ ଆପେଲାଣ୍ଟ ମାନେ ଆରେଷ୍ଟେଡ ହେଇଗଲେ ଘଟଣାର 2-3 ଦିନ ଭିତରେ, ଅର୍ଥାତ୍ 12 ତାରିଖରେ ଆରେଷ୍ଟ ହେଇକି କୋର୍ଟ ଫରୱାର୍ଡ ହେଲେ, and there is no evidence that they were hardened criminals or they threatened this PW 37 not to disclose anything like that. ଏବଂ पुलिस आपनकर इन्वेस्टिगेशन कमेंस कला, FIR लॉज ହେଇଛି 10 तारीख रे, तो इन्वेस्टिगेशन कमेंस फ्रॉम दैट डे, from 10/10/2017 11:15 तो प्रश्न उठुची जे in spite of the commencement of the investigation from 10/10/2017, if this man was aware that the person who had come to his shop had died, murder was committed, and 2 persons who had also come with them, they have been involved and they have been forwarded. So why he did not disclose immediately to the police? Why he kept mum till 17/11/2017? That means a month and 7 days or 6 days. He remained silent, and for the first time he disclosed. What is your explanation? When a witness is giving a statement at a belated stage, not disclosing before anybody, then this belated disclosure creates a doubt and about the authenticity of his version. हाँ, appellants माने सेमती hardened criminal ହେଇଥାନ୍ତେ, ଧମକ ଚମକ ଦେଇଥାନ୍ତେ ଯେ ଯଦି କାହାକୁ କହିବୁ ତାହେଲେ ତତେ ଆମେ ମାରିଦବୁ, ତେଣୁ ସେ ଅପେକ୍ଷା କରିଥାନ୍ତା ତାପରେ ଆପେଲାଣ୍ଟ ମାନେ ଆରେଷ୍ଟ ହେଇଗଲା ପରେ ସିଏ ଏ ବିଷୟରେ ପୋଲିସକୁ ଡିସକ୍ଲୋଜ କରିଥାନ୍ତା ବା ଅନ୍ୟକୁ ଡିସକ୍ଲୋଜ କରିଥାନ୍ତା ମ୍ୟାଟର ଇଜ ଡିଫରେଣ୍ଟ
Come to IO statement whether he has explained
Just on.
the delay.
Para
Let us see
28.
28. Come to that.
Come to that. Volume one.
28
Para 28.
yes ସେଇ 17/11/2017 ସେ କହୁଛନ୍ତି ନା on 7 please read it out
17 on 17/11/2017, I had examined one Girish Kumar Sahu, P37. After his examination, my investigation reveals that P37 was running a shop in front of the foreign liquor shop of one Bihari, not named, and at about 9 to 9:30 p.m. of 9/10/2017, both the accused person had been to his shop along with the deceased Viranj, who purchased Chakna, and they had been to his shop through a motorcycle. On that day, after purchasing liquor from the foreign liquor shop,
He doesn't explain. He doesn't explain the delay.
not explaining.
Not explain. You only say that I have examined on that. That's all. Is there anything in the cross examination?
no
It is part of the cross-examination.
Part of cross, huh?
Yes,
Okay. And there is nothing, no explanation is coming forth. The delay of about 1 month, nothing is coming forth.
so one thing is the delayed in disclosure, second thing the source of light available in his grocery shop to identify the appellants and the deceased properly so as to identify them in court after 6 years without any TI period.
So this is the admitted position. Isn't it, Mr. Tripathi?
Yes.
You can't improve it. This is the position which is admitted.
And of course, 161 statement, it is very clear that ସେ 3 ଜଣ ଯାକ କାହାକୁ ଜାଣି ନଥିଲା 2 ଜଣ ତ ମନା କରିଦେଲା ଜାଣି ନଥିଲା but 161 ଯେଭଳି ଦେଇଛି ଯେ 3 ଜଣ ଆସିଲେ ମୋ ଦୋକାନରେ ବସିଲେ ତାପରେ ପଳେଇଲେ ଏଇ ଟାଇପର ଷ୍ଟେଟମେଣ୍ଟ ତେଣୁ କାହାକୁ ଜାଣିଥିଲା ବୋଲି ତା ଭିତରୁ unfortunately that part could not be confronted. So
and one more interesting thing, if you see the recovery of the dead body, Biranchi's dead body was recovered 25 kilometers away from the house of the deceased, and whereas the Ekalavy's dead body was recovered 2 kilometers away from the second spot, that is the dead body of Viranchi, that is then 27 kilometers away from the house of the deceased. If the last scene theory is relatable to Biranchi, then this boy should have been there because his dead body was found in 27 kilometers away. That part is also unexplained. And the third dead body was found near the house. And all these incidents happens within 24, less than 12 hours. All the 3 murder, if the facts of prosecution is to be believed. Because this happens at after 9:30 on 9th, and next day the dead bodies are recovered.
8.
And all the dead bodies are in different places.
Biranchi dead body was detected on when?
On 10/10/2017 at 3:35.
Paragraph 21 of the IO statement.
Yes.
Body detected.
At page 195.
Yes. 25 kilometers away from the house of.
On केबे 10 तारीख ना?
10 तारीख है 3:35.
10/10/2017 at 10.
10 in the 3:30 spot.
10/10/2017 at 3:35 p.m.
And next page, if you
This
see,
is the evidence of IO.
Yes.
Huh? PW 41. Paragraph कितने?
21 minutes. one thing I may draw to your lord's attention, my lord.
1 minute, let us complete it. The second dead body is found 2 kilometers away from the second spot. And the second spot is this one. 2 kilometers away means 25 plus 2, 27 kilometers away from the deceased house. If it is the last scene is related to him, this boy should have been there. So this has to be explained by the prosecution. And the third body is found just seen 87 feet away from the house.
It was found, the Biranchi dead body was found on under the Pokhanda bridge, na?
Yes, my lord.
Pokhanda. Okay, when they left the house, grocery shop of PW 37, they told that they were going towards Kalapatanolai, right? So whether this Pokhanda bridge falls on the way to
Yes,
that is there.
Yes.
So who has stated?
Between 37.
PW 37.
That is
Fine.
Para 2 minor.
Para 2.
They had decided to go Kola Patna to see the melody on way Pokoda Bridge forms.
Woody.
Page 174, last line. They
decided to go to Kola Pattanari to see the melody. On the way, Pokonda bridge comes. So PW 37 is this evidence has been put to you in the 313 CRPC statement. What are the question numbers so far as apparent number 1 is concerned? Apparent number 1, 313 CRPC statement. At which question and which page? Age of PW 37 evidence.
page 75.
Apparent number 1.
Yes, 75.
Page 75, question number
128.
128.
Apparent number
55, page 55.
Page 38, Miller, Prakash Behra, appellant number 1. Page 38, that is starting from paragraph. It's actually page 37, question number 127. 127.
Question number 127 and page usi kete paper book
37.
Page 37 paper book 1.
Volume 1.
Volume 1 paper book.
And appellant number 2.
Appellant number 2.
75 page.
75.
Question number 127.
Question number
127.
Same question. And you answer uchi micho.
And here questions are the 3 questions.
127, 28, 29.
And 25.
127, 28,
29, 30 also.
30.
Yes.
128, 129, 130. Same question, Shabu Mana. That's all.
So this is all about the last scene.
What was the cause of death of the deceased, Biranchi? Who is the PM doctor?
PW.
exhibit 5 stars.
No, no.
Withdraw.
Doctor who conducted PM examination.
No, the PW,
Viranchiro postmortem paper.
PW is
Shaw.
Shaw.
And what he has seen and what is the cause of death.
The D 105.
Page number 105.
105.
Anil Kumar.
Volume 1.
Deep throat cut injury.
Deep throat injury over small of the neck, including cut of.
Yeah.
Death is homicidal and antemortem in nature. The injury is caused by sharp and hard object.
Now you see, if they had come together, Mr. Tripathi, they had come together in a particular motorcycle, they purchased liquor and then came to the shop of PW 37, took the water pouches, use and throw glass, mixtures, and then they sat there for 10 to 12 minutes and consumed it, and then they left to see the melody. So this evidence which has been adduced by PW 37 shows that there was very good relationship between the two appellants and the deceased. So why they will commit murder of the deceased?
That's it.
What is your explanation? What is the motive behind the commission of the crime?
And the motive behind commission of this crime is that that's it. We have to go to the evidence of PW 30.
Just a minute.
This is.
The copy.
Yes.
1032.
Page 169.
I mean,
It's 169.
1032. Eklavya Kumar, same injuries, the injuries. 105 compare. Compare same injuries. And why where is the Tarani's, who is examined Tarani? Who is doctor? Let us see the injury with a similar pattern of injury.
PW
PW 12. Neck cutting. 117.
Page 117.
Pattern is almost same. All three
persons were died similar injuries, that the neck was cut and okay, yes, motive you are telling.
Yes.
Who is the witness?
36, PW 36.
36.
I mean, 169.
16.
169.
169. Volume 1.
116. Yes.
The last scene you have recorded, then you are commencing motive.
Yes.
PW 36 is the witness. Please place it, Mr. Molia.
I know the accused person standing in the dock. I know their name as Ganga Sethi and Bhenoy of Ganga Sethi. I know the deceased person named Tarinai, Viranchi Naik, and their son named Nabalas Ekalabanai. The incident had taken place about 6 years ago, that is, in the year 2017. At that time, I was residing in the house of deceased Viranchi Naik. In their house, apart from me, Viranchi Naik, his wife, his son, and one of a small daughter were residing. Due to my illness, I had been to the house of Katyanai at about 10 a.m. on the date of occurrence. Now, on the next day, I came back to the house of Biranchi on 10/10/2017 at 8 a.m. When I came to the residence of Biranchi along with one Augustine, found that the residential house of Hajin closed from the outside with Gandhi and the window was half open. Then I called Biranchi, his wife Tarinai, his son Nabba, alas Economite, but I got no answer. At the window side, I could see bloodstain, and then out of fear, I ran away towards his old residence house of Biranchi. On the way, I found the third part, dead body of the Tarinai, which was lying inside order carry. Then I informed the fact to the younger brother of the Biranchi Naik, namely Sushanta Naik, his wife and his mother, namely Ketagi Naik. Prior to the occurrence, that is on 7/10/2017, while I was staying in the house of deceased Biranchi Naik, actually Ranja City had come to his house, come to his residence at 9 p.m., addressing Biranchi Naik as Bhanaja, and inquired about the loan amount received from one Annapurna Group, and whose account was maintained in the Bank of Goinda. On reply, Biranchi disclosed to Ranja City that he had received the loan money, but same has been kept by one of the members of the Annapurna Group. Very important. Then he left the house of Biranchi and came again to the house of Biranchi on 8/10/2017 at about 7 p.m. Then actually Ranja, along with Biranchi, left the house for the purpose of mobile charging and moved to the house of one Dilip Sethi. On 9/10/2017, actually Ranja came to the house of the accused Biranchi and was calling as Bhanaja. When I was present in the house, hearing the calling of Ranja Sethi, Rishi Tarani came and informed that her husband is not present. At that time, actually Ranja asked Tarani regarding the purchase of motorcycle after receipt for the money. On reply, Tarani Naik said that her husband already gone to Kishannagar to repay the loan, and she does not know regarding the purchase of motorcycle. On that day, at about 10 a.m., I left the residence house of Biranchi and moved to the house of Katyanai for my treatment. During the Panchayat election of year 2017, mother of the Ranja Sethi was contesting for the post of Sarpanch, and at the same time, wife of Dilip was also contesting for the post of Sarpanch. During the election campaign, Mrs. Biranchi was supporting to the wife of Dilip, who won the election, and the mother of the Ranja Sethi was defeated. For the above political relation, there was enmity between the Ranja Sethi and Mrs. Biranchi. I have had all about the friends blessing from the mouth of Mrs. Biranchi.
Aro appellant number 2 ro ma सरपंच contest କରୁଥିଲା ତା କାହା ସାଙ୍ଗରେ ଦିଲ୍ଲୀପ ର ସ୍ତ୍ରୀ ସାଙ୍ଗରେ ଦିଲ୍ଲୀପ କିଏ
wife of Dilip.
ଦିଲ୍ଲୀପ କିଏ
Dilip is third person.
ତାହେଲେ ଆ ସାଙ୍ଗରେ ଶତ୍ରୁତା କଣ?
He was supporting Dilip's wife.
Oh, achha. During election, this is Biranchi was supporting to the wife. Achha. और ସେଇଥିପାଇଁ ଇଏ କଲା ବୋଲି କହୁଛି
Dilip Sethi is PW11.
PW11.
11.
Yes. Achha, I have heard all about the strained relationship from Biranchi.
From the mouth of this
Biranchi. Achha.
But still they were close.
Mamu.
Yes, so what you have elicited in the cross-examination?
I am a married lady, but never visited.
And let us be clear, the Mr. Tripathi, whether the intention is regarding the election enmity or that something to do with the loan amount.
Of the loan amount.
1 minute. What is this? There are two distinct stories.
Yes.
One story is regarding the loan amount.
Loan amount.
Is the motive is related to the loan amount or the election enmity?
Well, here two things that have come out, and
Or both.
Or both.
Both. And let's see kindly.
Political, just a minute. Political hostility. Second is loan amount. Yes. Acha.
That's you kindly turn to page 162, Milord.
No, we'll
No,
go
let
to
us
that.
conclude the cross examination. Let us. Yes.
Yes, you place the cross examination.
I am a married lady, but never visited my in-law house, which is in the Denkan district. I was residing in the house of Biranchi Naik on rent after 6 months of marriage. At the time of Biranchi Naik and his 2 sons, 2 children were residing, I was resided in the house of Biranchi as his wife and was taking care of his 2 children along with all other household affairs. Biranchi was taking care of me as his wife. I did not object.
Biranchi was?
What Biranchi
He was
was?
taking care of me as his wife.
What is this?
Witness it is his wife.
Then it sounds is interesting.
ତା ଘରେ ଭଡା ରହୁଥିଲା କିନ୍ତୁ ଇଏ ତାକୁ ନିଜ ସ୍ତ୍ରୀ ଭଳି ଦେଖୁଥିଲା ତାର ଯତ୍ନ ନଉଥିଲା ଏଇଆ ତ
I was resided in the house of the Biranchi as his wife.
Yes, ତାପରେ
Like his wife and as his wife, there is a difference.
care of me
Like the wife, I can understand. As wife.
care of his as his wife ମାନେ ସ୍ତ୍ରୀର ଯେମିତି ଯତ୍ନ ନିଏ ହଁ ସେଇଭଳିଆ ଯତ୍ନ.
Had it been like the wife, it would have been different.
I was resided in the house of Biranchi as his wife.
I did not object the second marriage of Biranchi Naik with the deceased Tarani.
କୋଉଠି ହେଲା as his wife କହୁଛି କୋଉଠି
Resident of
Para 7 lang Court line.
para
7.
I was residing in the house of Biranchi as his wife. अच्छा ठीक है. And अच्छा
Second.
I did not object the second marriage of Biranchi Naik with deceased Tariff Naik. The residential house of the Katia Naik situated at distance of 300 meters from the house of Biranchi Naik. I was examined to police on 10/10/2017. Wife of Katia Naik used to give body massage for the treatment of Rokka Pasigala. I cannot say the time in the court wall clock. I have no idea about the hour, minutes, and seconds. The date of today is 10th. And I cannot say month and year 2023. I have given my statement to the police. The police read over and explain my statement to me. From the statement, I remember the date and time. While I was returning with leg pain, choti from the house of Katia Naik, I met Jadumani and Augusti on the way, and Augusti along with me came to the house of Biranchi Naik. I cannot say about the Jadumani whether he was standing on the road or went away. Seeing the blood stain at window, I ran away towards the old house without opening the janji. When I came, the house was with the janji. Window was half open, and on the call, when none did not respond, I suspected the situation. The bleeding due to death of a mouse and injury on the finger due to window closing is not same bleeding caused due to axe assault. After seeing the blood on the window, Augusti went away and I started running from the spot. Out of fear, we both left the spot and I informed the facts to their family members that informing to the police. I have never lost their care. There is a Mamu Bhanja relationship between accused Ranja and deceased. I have never seen visit of accused Ranja Sethi to the house of deceased Biranchi Naik prior to 7/10/2017. At the time of visit of Ranja Sethi, Biranchi Naik just reached at his house on 7/10/2017. Ranja Sethi and Biranchi Sethi were talking with each other at the back side of their house, which is on a road. While they were talking, I was standing at Duara. At the time, no other outsider was present with them. It is not a fact that accused never asking for money from Biranchi Naik, and that I had never heard their conversation as I was not present there. There is no electric connection in the house of Biranchi Naik. I have no idea whether the business of Biranchi Naik was running well, and in order to avoid his family members, such as brother and mother, was residing separately. Till death, Biranchi lived as a gentleman. He never quarreling with any of the villagers. I cannot say when Biranchi and Ranjaseti had good relationship between them. I have no business talk with Ranjaseti. It is not a fact that I know such good relationship with Ranjaseti. I do not remember in which year Panchayat election was held. I cannot say to which post the mother of Ranjaseti was contesting in the Panchayat election. Biranchi Naik was supporting to wife of Dilip during the Panchayat election. Wife of Dilip was contesting for the post of Sarpanch. I do not remember to which post mother of Ranjaseti was contesting in the Panchayat election. It is not a fact that mother of Ranjaseti was contesting for the post of ward member, and that I moved to see the dead body of Tari Naik after getting information from others. And prior to my arrival, the death of Tari Naik was already spread in the village, and that no such enmity was existing between Ranjaseti and Biranchi relating to the Panchayat election. That accused Ranjaseti committed murder of Biranchi, the money is false. That accused Ranga and Mandari Sethi and Babulai Prakash Vera no way connected in this murder case. That I was never retained by the police in connection with the case. The police had never recorded a statement relating to this case, and it was false evidence for the first time report.
Yes.
So you see, even if the statement that there was some kind of dispute between the one is relating to the political matter, because the appellant's mother was contesting for the post of Sarpanch, and wife of one Dilip was also contesting, but the deceased Biranchi was supporting the wife of Dilip. That is one reason you said. The other reason is that there was an Annapurna group, and that account is maintained in the Bank of Boenda, and the appellant number 2 was told that the deceased received some loan amount and it was kept with one of the member of Annapurna group. So let us say এই টাইপର ଗୋଟେ ତାଙ୍କର ଗ୍ରୁପ ଅଛି ଯୋଉଟା ବୋଧ ହୁଏ ଏଇ ଯୋଉ ଯାହାର ଯୋଉ ଲଟରି ଉଠେ ସେ ଟଙ୍କା ନବ ସେ ସପ୍ତାହକ ପାଇଁ ବା ମାସକ ପାଇଁ, ତ ସେଇ ପ୍ରୋସେସରେ ବିରଞ୍ଚି ସେ ଟଙ୍କା ସେ ଲୋନ ଟଙ୍କା ନେଇଥିଲା ଏବଂ ସେଟାକୁ ସେ ରଖିଥିଲା ଗୋଟେ ଅନ୍ନପୂର୍ଣ୍ଣା ଗ୍ରୁପର ଜଣେ ମେମ୍ବରଙ୍କ ପାଖରେ। So ଏଇ ଯୋଉ ଦିଟା ଆପଣ କାରଣ ଦଉଛନ୍ତି, in spite of that, if they are moving together to see a melody party taking liquor together and enjoying the company, can it be said that the relationship was so strained that one would commit the murder of the other?
But
PW11 is another.
yes, at page 170, Miller, at paragraph 3. His witness says that Ronja Sethi had come to his residence at 9 p.m. addressing Biranchi Naik as Bhodajamal. On good faith, he might have gone. Now, let's kindly turn to page 162, Miller, and it relates to exhibit 26. 162. Deposition of witness PW 34. It is the bank manager.
Yes.
On 2010-2017, let's see.
Yes, got it.
I was working as branch manager SBI Timiri Munda Kishore Nagar branch. On that day, IIC Kishore Nagar had visited the bank and took the account details of one Biranchi Naik, and I had provided the account details of said Biranchi to Kishore Nagar IIC with seal and signature of branch manager. Exhibit 26 is the said account details provided by me, being the branch manager, and exhibit 26 by 1 is my signature thereon. On 9/10/2017, the account holder had deposited cash of rupees 1 lakh in his account, and total balance of the said account was 1,20,520 million. So far this loan, availing this loan from self-help is concerned, Miller. He deposited 1 lakh rupees.
हाँ जितेबाला अरे गोटे माने मु पर्टिकुलर गोटे अमाउंट लोन आमर गोटे ग्रुप करथिलु ते ग्रुप रे मन कर जहार उठिबो लॉटरी बा ये एरा ऑर्डिनरली हुए तो ताकू से टंकाटा मिले कम इंटरेस्ट रे राइट एंड से टंकाटा को पुनी नेक्स्ट मंथ रे हुए तो आउ जनकर कार उठिबो तेणु किछि लोक कंट्रीब्यूट करथांती एवं कंट्रीब्यूशन कला परे जहार उठिला से अमाउंट निये एवं ता गोटे टाइम दिया तो एति दिन भीतर डिपॉजिट करिवो कम इंटरेस्ट जोटा की बैंक रे हेले हायर इंटरेस्ट पड़ो ते एई टाइप रो ग्रुप गोटे करा जायता है एवं से टंकाटा तार जदी उठिला से ताकू नेकी निज अकाउंट रे डिपॉजिट कला 1 लाख अमाउंट तो कौन हेला माने हाउ इट क्रिएटेड हॉस्टिलिटी or enmity with the accused, the DC appellant Ranja.
PW11. PW11. 114. Come to 114. 114. Now read it. 114.
It's just a statement of
Sanatan Bipin
Bihari Naik.
Read it.
I know the informant and accused person standing in the dock. The occurrence took place in the year 2017. On 12/10/2017, the accused Prakash Behera and Nandakishore Sethi confessed their guilt. The accused Prakash Behera stated before us that the deceased Biranji Naik had obtained loan of rupees 1,75,000, and therefore both the accused persons had planned to rob the deceased. He also stated that he, along with accused Nandakishore Sethi and deceased Biranji, went together and he cut the throat of the deceased Biranji by one chopper. Then they went to the wife of the deceased Biranji and also killed her by the said chopper. Then they took the son of the deceased and killed him near Pokonda jungle. Therefore, he stated to have concealed the said chopper and blood-stained towel near a bush. He also stated to have concealed his wearing apparels by digging a ditch near Boromopada. Thereafter, both the accused person led us to the place of concealment, that is the land of Boiragi Naik at village Pokonda. On the same day, at 9:30 a.m., the police seized the chopper and the one blood-stained towel on production of the accused person in our presence. This is the said confessional statement of the accused Prakash marked Exhibit 18, and this is my signature on it marked Exhibit as Exhibit 18 by 1. This is the said seizure.
This is a statement which has been given in the police station. In the cross-examination, it has come. So it is not, you come to the cross-examination, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line from the cross-examination.
During the confession, the accused
both the accused persons admitted their guilt in the police station, for which police got them to village Swanso. I was not present in the Kishon Nagar police station during the confession of the accused persons. Allah, I cannot say why the police had brought the Swanso. The content of the confessional statement was read over to me. I cannot say whether there was any Swanso. So this is not that somebody went to him, voluntarily confessed, so that it would be admissible as extrajudicial confession.
It is not in the nature of extrajudicial.
It is just a statement recorded under Exhibit 18, and that was recorded in the police station, and he has just signed it as a witness, but he himself says that I was not present when the confessional statement was recorded. That means his signature was recorded in the confessional sheet after it was recorded, much after. Karana police station re confession heichi, si jetebale ki sie nathila, তারপরে এই কনফেশনাল স্টেটমেন্ট এক্সিবিট 18 সে সিগনেচার করেছে।
Page 164, another statement may be relevant. Page
PW?
1, page
PW?
160, PW 35. Is another case.
And you will have to show exhibit 18, huh? Subsequently. 164.
Yes.
Okay.
Exhibit 18. Now, 164 minute, he is another Girish, but Girish Chandra Naik,
PW कहते हैं?
PW 35.
वो intellectual figure था।
On asking these two accused person confess their guilt in the police station.
Good.
From last part of the first paragraph.
No, you read the from the very beginning.
Yes, madam. I know the accused person standing in the dock. I know their name as Babuli Behra and Ronja Sethi. This incident had taken place about 6 years ago. During the incident, there was murder of 2 persons by cutting their throat. After 2 days, police personnel from Kishornagar PS moved towards Gothamundia jungle, Birimunda, Pokonda of village. Seeing the movement of police, we moved behind the police and saw that these 2 accused persons were standing near the police. On asking, these 2 accused persons confessed their guilt. Accused.
This is hit by section 25 of the Evidence Act. No? Any confession made to the police, that is not admissible. So this is nothing. Only so much of statement which gave led to the discovery of any.
Paragraph 3, there is discount.
Yes.
Yes, sir.
That part will be.
Yes, sir.
This weapon of one weapon was seized, and their gamucha.
May I read from paragraph 2, Miller?
Yes, sir.
2. After I am reading at paragraph 2, Miller. After commission of order, he kept in hiding the blood-stained gamucha along with one kotuni at a distance of 100 meters from the place of confession. Babuli also confessed that he kept in hiding his blood-stained pant and shirt at Brahmanapada Nola project. Then Babuli disclosed before the police that if he will be taken to that two places of hiding, he will keep the recovery of the offensive weapon used by him. So also the blood-stained cloth which includes gamucha, 1 pant and 1 shirt. Police recorded the confessional statement in my presence in skipping that paragraph 3. After such recording, accused Babuli led the police along with the witness to the place of hiding to give the recovery of offensive weapon and the blood-stained cloth which include gamucha. Then police along with witnesses moved to the spot and accused Babuli gave recovery of blood-stained gamucha along with koturi from Bausa Buddha of Boiragi Naik. Police took the measurement of koturi and length of the koturi would be around 14 inch to 15 inch long. The koturi was completely prepared from iron and there is no such wooden handle. I can identify the said koturi if will be produced for me. After such recovery, police prepared the seizure list in the presence of myself and accused persons, namely Babuli Behra and Ronja Sethi. Police prepared the seizure list at 9 to 9:30 a.m. and after going through the content of seizure list, I had put my signature thereon and left the spot for my urgency. And police moved towards BD Singha near Brahmanapada project to recover the blood-stained pant and shirt kept in hiding by accused Babuli Behra. Accused Babuli Behra is also known as Prakash Behra. One Bipin Naik also had put his signature on the seizure list along with the 2 accused persons. I was examined by police in connection with this case. Exhibit 18 is the said confessional statement, 2 sheets below. Thereafter, paragraph 6 is the Memo. This is the confessional statement.
So you see so much of you come to section 27 of the Evidence Act. what it says, prior to that you come
Go
to
Evidence Act.
Evidence Act section 25.
You have the act. If you
So
have.
no confession made to a police officer shall be proved as against a person accused of any offense. 24(5) is very clear. Hala? Then confession by accused while in custody not to be proved against him. So no confession made by any person while in the custody of the police officer unless it is made in the immediate presence of magistrate shall be proved against him. So that goes. Only section 27 is an exception which says that how much of information received from the accused is to be proved. That says that if any fact is deposed to and that lead to the discovery of something, only that part is admissible, so much of statement. ତେଣୁ ଏଇ ଯୋଉ ମୁଁ ତାକୁ ମାରିଛି ମୁଁ ଏମିତି ଏଇ ଖଣ୍ଡାରେ ମାରିଛି these are all to be excluded because it amounts to confession and that part would be hit by section 25. ମୁଁ ଗୋଟେ କଟୁରୀକୁ ବା ମୁଁ ଗୋଟେ ଗାମଛାକୁ ଏଇ ଜାଗାରେ ରଖିଛି ମୁଁ ନେଲେ ସେଇଟାକୁ ଦେଖେଇଦେବି so ତାପରେ ତାକୁ ଲିଡ୍ କରି ନେଇକିନି ସେଇ ଜାଗାରୁ ସେ ଜିନିଷଟା ଦବ. That much would be admissible under section, provided that you are to prove again that that is the weapon of offense, right? So मने करा जाऊ जे गोटे weapon जोटा कि होची गोटे कटुरी सेटाकू एई बाबुली बाहर करिकिनी देला एवं ता सहित गोटे गामछा मध्य बाहर करिकिनी देला जो गामछारे रक्त लागितला एवं कटुरीटा मध्य आपणकर एठी पठाइछि जो डाक्तर पाखकू 3 जण जो डाक्तर पोस्टमार्टम करचंती से माने कहउचंती एई टाइप रो कटारी रे एई टाइप रो इंजुरी हेई पारिबो. But what is the DNA test report about the cotton?
Exhibit 59, let's kindly turn to volume 2, page 349.
You are on motive. Motive you have concluded. Motive. Okay. There is nothing on motive now. Motive, then you are relying upon PW 36, 11 and 35.
Yes.
That's all.
No, PW 36 रो छोड़ा तो आगे motive विषय कौन आती?
PW 36.
Only witness, not PW 11 and.
But he is relying upon 11 and 35. No. And what about 30? What about 17? 17 also has said something. Just see 17. Shanti Naik.
No.
133.
11 PW 11 motive विषय कौन पूछी?
PW 17 133 million.
पैसा आस्तिला ये आस्तिला क्या?
That is 1,75,000 and 1 lakh was deposited in the account.
That's right.
Let's kindly turn to 133.
PW 17.
PW 17.
Yes.
I know the informant Sushanta Naik. I
PW
know the
17.
17.
133.
I know the informant Sushanta Naik. I know the accused persons, namely Prakash Behra and Nandakishore Sethi, standing in the dock. I know deceased Tarini Naik, wife of Viranchi Naik. One Ranja Sethi alias Prakash killed Tarini Naik. I have heard about the incident from my villager. I am one of the working member of Ma Moheswara SSG group. About 5 years ago from today, we had been Boinda to collect cash from Annapurna Microfinance and each of our SSG group received cash of ₹25,000. I had given hand loan of 25,000 to Biranchi Naik. I, along with other 6 persons, had given hand loan to said Biranchi Naik to purchase one pickup van. Said Biranchi Naik took hand loan from us on 8th and he had been to deposit the said amount on 9th. And thereafter, he was murdered on 10. Deceased Biranchi Naik is the husband of deceased Tarini Naik. Their son Ekalabya is also murdered. All the 3 persons are murdered by accused Ranja Sethi to take away the cash which he had received to purchase a pickup van. Director PW 11.
11.
No, read that cross examination.
I have not seen.
I have not seen the actual incident of murder. I have not specifically mentioned before the police from whom I have heard about the incident. We have never handed over any document regarding Ma Maheswari SSG group and withdrawal of our cash of rupees 25,000 from Annapurna Microfinance. We did not receive any receipt from the deceased Biranchi Naik. On the very day of incident, I was examined by police near the house of deceased Biranchi Naik. Deceased Biranchi Naik is my brother-in-law, Diara. The residential house of deceased Biranchi Naik situates at a distance of 1 kilometer, and accordingly, I have no knowledge about the persons coming to the house of Biranchi Naik. It is not a fact that I have not stated before IO that accused Ranja Sethi had killed all the 3 deceased, and I have never given any hand loan to deceased Biranchi, and that murder of deceased Biranchi for the huge cash is false, and that accused Ranja Sethi and Vikas are no way connected in this case, and that being relatives of deceased Biranchi, I am deposing falsehood.
Now 3 figures are coming.
Yes.
PW 11 says 1,75,000. And you have read out the statement of the banker who says 1 lakh is deposited. And this gentleman is now saying it's 25,000.
25.
Which is that figure for which the robbery was supposed to be taken place?
Yes.
You have brought up this evidence on record, bringing 3 different figures.
Robbery charge has been disbelieved, I think.
Disbelieved. Yes, yes. But these are the 3 figures you are bringing on record. He says 25,000. You have examined one bank officer who says 1 lakh rupees is deposited. And PW 11 says that 1,75,000 rupees was there, which was supposed to be robbed by these people, therefore this crime has taken place. Which figure is to be believed? Yes.
Oh, what is the motive?
Motive is not coming for.
This
So far, PW's 36 statement is concerned. Ranja Sethi went to the house of Biranchi.
Which statement?
36 million.
Para 3 million. Very important.
Para 3.
Last time, money was not with us, given they deployed the money.
Yes.
36 million.
But you face 170.
One?
एथिपाई तार कौन पाई डिसीज्ड ऊपर राग हबो यदि ए जो पैराग्राफ नंबर 3 ऊपर कहउछंदी ए जो अपेलेंट्स मानकर यदि गोटे अपेलेंट रंजी सेठी से कौन कहउछि जे 7 तारिख दिन मु बिरंची घरे रहउथिली रंजो सेठी आसिला सेते बेलकू राती 9टा हेइतला बिरंची को डाकिला भणजा एवं पचारला ए साखी को जे जो अन्नपूर्णा ग्रुप रु जो लोन अमाउंट पाइबा कथा बिरंची कौन हला सी कहला 36 नंबर साखी कहला जे बिरंची डिस्क्लोज टू रंजू सेठी that he had received the loan amount but the same has been kept by one of the members of Annapurna group. So money was not with this Biranchi. Biranchi said that it was kept with one member of Annapurna group. So is there anything that the appellants had given any loan or Biranchi had to pay something to any of the appellants and he did not
Or it was
pay?
there in the house so that these people went for robbing it.
Yes, Miller.
And the figure is not coming forth correctly.
No, robbery charge has been disbelieved. Matter ends there. You are not challenging in the appeal that any of the acquittal order. So, question is that you are now harping on a motive. Two motives, 2 reasons this motive has been assigned. One is this political hostility and the second is the loan amount. Loan amount, we do not find anything in connection with the appellants. How it is relevant? सी लोन नहीं थिला से अन्नपूर्णा ग्रुप रु सी आनिला ताकू डिपॉजिट कला या संगे अपेलेंट मानकर कोन संपर्क सी जदी कहला जे डिपॉजिट हेई जाईची हां तो डिपॉजिट हेई जाईची गोटे बैंक मैनेजर मध्ये कहूची जे से ऑलरेडी डिपॉजिट करची 1 लाख तो केते टंगा से लोन पाइला कोन डिपॉजिट कला अपेलेंट मानकर तार सी कोन if there would have been anything in that
They are
respect.
in any case are they affected because the loan is granted to them? They are not affected.
Suppose ସେମାନେ ମନେ କରନ୍ତୁ ଅନ୍ନପୂର୍ଣ୍ଣା ଗ୍ରୁପ ର ମେମ୍ବର୍ସ ଥାନ୍ତେ ଯୋଉଥିରେ କି ତାଙ୍କୁ ଲୋନ ନ ମିଳିକିନି ବିରଞ୍ଚିକୁ ମିଳିଥାନ୍ତା
At their cost.
ହଁ ତାହେଲେ ହଁ ଗୋଟେ ହୋଷ୍ଟିଲିଟି ଆସିଥାନ୍ତା ସେମିତି ତ କିଛି ନାହିଁ
This story can't be.
ଇଏ ଗୋଟେ ଏଇ ଯୋଉଟା ରିଜିନ ଟା ଦେଉଛନ୍ତି ତାପରେ ଇଏ ଜଣକୁ ସପୋର୍ଟ କରୁଥିଲା ସରପଞ୍ଚ ଇଲେକ୍ସନ ରେ 2017 ରେ ଆଉ ତାର ମା ଛିଡା ହେଇଥିଲା ଆଉ କିଏ ଜିତିଲା କିଏ
Dilip's wife.
ଦିଲ୍ଲୀପ ୱାଇଫ ଜିତିଲା
Para 15 I go there, I do not remember in which control head a cannot say to which post the mother was there to contesting.
which one
Para 15 months.
And the cross
Page
again.
1 sir.
Not even sure which post.
I cannot say to which post mother of this sarpanch jo kouchi that are doubtful of Biranchi Nayak was supporting the wife of son during the panchayat election. Wife of Dilip was contesting for the post of sarpanch. I do not remember which post mother he was contesting with.
Page 112.
112.
That is the position of Dilip Sethi.
Under 12 or how much?
Dilip Sethi, whose wife won the election. Not.
କିଛି ନାହିଁ ଏ ଦିଲ୍ଲୀପ ସେଠୀର ୱାଇଫ ମୁଁ କହୁ ସିଏ ମଧ୍ୟ କହୁନି ଯେ ମୋ ୱାଇଫ contest କରୁଥିଲା.
Rather, he says something else. Para 2. He says that it is a case of robbery which has been disbelieved by the High Court, trial court. See, para 2, read it.
Police searched the house of deceased. Almirahs and the boxes were broken. Later, the police found the dead body of the deceased Biranchi Naik and Ekalavya Naik. We suspected that due to money of Annapurna group, the deceased persons might have been killed. Police seized one motorcycle and one half shirt in my presence. This is the said seizure list.
You brought this witness to prove something else. He's saying something else.
Robbery loan से आनीथिला 1,75,000 टका.
ନାଇଁ ସେ ୱିଟନେସ୍ କୁ ଆଣିଥିଲେ ଇଲେକ୍ସନ କଥା ପଚାରିବା ସେଟା ଆପଣ ପଚାରିକି
ଇଲେକ୍ସନ କଥା ଟୋଟାଲ ନାହିଁ.
You have brought this witness only to show that my wife has contested and there is enmity and all. Without asking that question, you have asked something else, which has been disbelieved by the trial court.
The husband of कौन सेटा कहार ये ता स्त्री ना कौन the election
wife of Dilip Sethi.
And brother.
And you should have asked Dilip Sethi.
It was not.
Your wife has contested with the mother of the appellant who has lost the election, therefore the enmity. Where is the question? Single sentence.
No, that is not.
Then why for you brought this witness?
Brother of Biranchi, Sushant Naik was also examined. He has stated about his political rivalry and other things.
Sushant
Naik, PW9, page 110. Paragraph 3. And
Election thing, huh?
Again, paragraph 3 and 6.
Dilip doesn't say anything. Dilip would have been a better witness to say this thing.
यारो witness टा जोटा कहउचंदी 36 नंबर साखी ସେ ତ ନିଜେ କହୁଛି ଯେ କୋଉ ପୋଷ୍ଟ ପାଇଁ ହେଇଗଲା ମୁଁ ଜାଣିନି।
Rusty Coleman.
ଆପଣ ସେଟା ଦିଲ୍ଲୀପକୁ ପଚାରିଥିଲେ ହେଇଥାନ୍ତା, ସେଟା ବି ପଚାରିନାହାନ୍ତି। ଆକୁ ପଚାରୁଛନ୍ତି ସୁଶାନ୍ତ ନାୟକକୁ। ସୁଶାନ୍ତ ନାୟକ has nothing to do with this election. You should have got it from the mouth of Dilip, these things. Para 310. He said Dilip is nominated.
ये जो 36 नंबर साखी जो पॉलिटिकल हॉस्टिलिटी विषय
interesting is nominated his wife as a ward member.
ମାନେ ଗୋଟେ ପୋଷ୍ଟ ପାଇଁ ଯଦି ଆପଣଙ୍କର 2 ଜଣ ଯାକ ଛିଡା ହେଇଥାନ୍ତେ ତାହେଲେ ଜଣେ ହଉଛି ଗୋଟେ ଆପେଲାଣ୍ଟ ର ମା ଆଉ ଜଣକୁ ଡିସିଜ ସପୋର୍ଟ କରୁଥାନ୍ତା ତାହେଲେ ଟୁ ସମ୍ ଏକ୍ସଟେଣ୍ଟ you are correct that might be there is some kind of political dissension ଯେ ଇଏ ଜଣକୁ ସପୋର୍ଟ କରୁଥିଲା ଆଉ ସେ ଆପେଲାଣ୍ଟ ର ମା ସାଙ୍ଗରେ ଲଢୁଥିଲା ଏବଂ ଆପେଲାଣ୍ଟ ର ମା ହାରିଗଲା ସେଇଥିପାଇଁ ଟିକେ ହୋଷ୍ଟିଲିଟି ଥାଇପାରେ କିନ୍ତୁ ବର୍ତ୍ତମାନ ଏଠି ଏଭିଡେନ୍ସ ଆସିଲାଣି ସେ ଯୋଉ କେତେ ନମ୍ବର ସାକ୍ଷୀ ସେଟା
ଦିଲ୍ଲୀ
PW9 ନା ଯୋଉଟା ଦେଖୁଥିଲେ ସେ କଣ ଯୋଉ ୱାର୍ଡ ମେମ୍ବର ପାଇଁ ଛିଡା ହେଇଥିଲେ PW9 କିଏ ସୁଶାନ୍ତ ନାୟକ PW9 ଏଭିଡେନ୍ସ କୁ ଆସନ୍ତୁ
110 para 3. Para 3. Navakishore Shetty had nominated. Navakishore Shetty is the appellant number 2. Nominated his mother and Dilip Shetty nominated his wife as ward members.
କିନ୍ତୁ ସିଏ କହୁଛି ସରପଞ୍ଚ ये वार्ड मेंबर नहीं ये सरपंच नहीं
The mother of accused Nanda Kishore Shetty got defeated, for which the accused had enmity with my brother.
ହେଲା ଯେ ସେ କହୁନି ଯେ ସରପଞ୍ଚ ପାଇଁ ଛିଡା ହେଇଥିଲେ ତ 36 ନମ୍ବର ସାକ୍ଷୀ କହୁଛି ସରପଞ୍ଚ ପାଇଁ ଆପଣଙ୍କର
interesting you read the para 3 full para 3.
In the Panchayat election of 2017, Nanda Kishore Shetty had nominated his mother and Dilip Shetty nominated his wife as ward member.
Read it complete.
What mother? Ward member.
Mother of the
accused Nanda Kishore Shetty got defeated, for which the accused had enmity with my brother.
Yes, next.
On Saturday, the accused Nanda Kishore Shetty had come to the house of the deceased and asked about the money of Annapurna Group.
See, the election to see the money policy. And on the Monday morning, he again came and inquired about
my brother.
And subsequently on the
same night, they had killed deceased.
So the motive is, you could not
secure evidence secure. Peter, you karan ଦେଇଛନ୍ତି लोन अमाउंट आउ जो पॉलिटिकल हॉस्टिलिटी सेमती गोटे स्ट्रांग मोटिव आपण एस्टाब्लिश करि पार नांती कैन बी सेड दैट हैव यू डेल्ट मिस्टर मुलिया ये जो दीटा रीजन जो मोटिव रो कुहा होची ताकू लिंक करिली केमती ए मोटिवटा has not been established. Have you dealt it in the written note which you submitted? Motive ro gote column karichandi?
No, motive you have not dealt specifically.
ताकू आजी प्रिपेयर करी नाणंतु मोटिव रो PW36 को नियंतु PW36 दीटा रीजन को होची पॉलिटिकल हॉस्टिलिटी आ द्वितीयटा होची लोन अमाउंट तार जो साइड एविडेंस गुड़ाक रोची how for those two evidence is not sufficient to constitute that the appellant had a strong motive for commission of the murder. So जो ancillary जो evidence गुड़ा का भी place हला ताधियोरु आणुतु कारण देखिले जे अपन करो सरपंच इलेक्शन की करानी वार्ड मेंबर तापरे से दीटा को कैंडिडेट की एग्जामिन ही ना
The second candidate name is not disclosed. The husband's name Dilip was disclosed, and when Dilip entered into the witness box, not a single question was put regarding the election thing.
कारण दीटा को कैंडिडेट से माने तो बेस्ट विटनेस ही था ना मु एती मु सरपंच पे चिड़ाई थली आ मते ये सपोर्ट करथला आ ताकू से कैंडिडेट को से सपोर्ट करथला से माने ही था बेस्ट विटनेस से दीटा के विटनेस एग्जामिन
husband lo witness la and husband is the or the rules. Koun hits political.
बाकी जो लोन अमाउंट को था जना पड़ी जे 1,75,000 टंका बीरंची लोन आनी थिला राइट
जमा कला
तो 1,00,000 टंका से दिन जमा करची बोली बैंक मैनेजर ने किए गोटे कहउछंती तो से दिन से केते टंका पाइला
and here another witness says 25,000.
Okay, पैसा रखी देई बोली बैंक के रखी देई बोली कहउती माने सारा फिट
Nothing is coming out very clearly. Things are very simple.
Episode paraphrase on reply, Biranji disclosed to understood they had received the loan of money, but same has been kept by the one of the member of the honorable group. Money were not used.
ये जो लिंक एविडेंस उड़ा है ना तले माने लोन हेडिंग रो ये पॉलिटिकल हॉस्टिलिटी रो हेडिंग रे सेटा गोटे पेज रे गोटे करिकिन दे दो लिंक करिन
Whatever now we discussed.
हां यह डिस्कशन हो कारण वर्चुअली लास्ट सीन और मोटिव ए दीटा हमें आज मेनली डिस्कशन करूछु है ना बाकी we'll come to tomorrow we'll discuss about the
medical evidence
DNA test ଆଉ seizure list obviously seizure list रे भी तार जहां बाहर ची that is linked with that DNA test report finding
and related 313 statement.
हाँ
Also you have to question number.
प्रत्येक circumstance रो सी relevant question पचरा है ची कि नहीं और यदि पचरा है ची कितने नंबर question who accused को और तारा आंसर तार एटा को ये कर दे ये जो तीनटा सीजर अपन चारिटा सीजर लिस्ट आपको आज आणु चंदी so far as the appellant number 2 is concerned हला appellant number 2 रो होची दीटा सीजर लिस्ट exhibit 1 और exhibit 4
ये one is important.
हाँ
One is important.
हाँ नहीं
One is related to DNA question.
हाँ exhibit 1 and exhibit 4 one टा होची relevant so far as DNA test पाई सेमती appellant number 1 रो दीटा सीजर लिस्ट 19 and 21 हला दीटा करो रेलेवेंसी अच्छी से जो डीएनए टेस्ट से विषय सेमती प्रिपेयर करचंती ये रे सो विल सी दैट टुमारो अच्छा विल टेक अप डे आफ्टर टुमारो दैट इज
So that at least one day you get time in between preparation.
लेफ्ट इट वाज नियर सी फॉर जस्ट टू ऐसे बामन को कहि देलो ये नाम प्रकाश बेरा नंद किशोर सेठी आउ एठी जहा ए विषय जो आलोचना होची सब सुनिले तो हाँ आपनकर जहा कहिबार अछि एठी वकील बाबू जो आर्गुमेंट करूछंती आपण सेठी जो वकील बाबू आपन पाखे अछंती ताके जरिया रे कहि पारंती आउ ए सुनानी पहर दिन को पुनी बुधवार दिन अर्थात 25 तारिख दिन 2टा बेले पुणी हम है हाँ ठीक अच्छे आउ आपण ये रहिबे से दिन आसीबे एवं रहिबे उपस्थित रहिबे
Are you in contact with the lawyer there? They want to say something, then how will they contact?
No, Mr. Mulia, please give your number, phone number to Mr. Das. आपण से मिस्टर मूलियाकर को आपण नंबर टा दियंतु से दैट दरकार पड़ले आपण को कांटेक्ट करिवे एवं को आपण तांको ठू इंफॉर्मेशन आनी जहाँ से दरकार आपण तो जणैबे
आपन फोन नंबर टा कोन तू
मोबाइल नंबर कोन
मोबाइल नंबर
77 35 180 10
डबल
55
कितने नंबर है देखो कितना है
10
आउटरे कॉल पचा दो
आउतरे कोन तू टिके
77 35 180
ठीक है
दिलीप कुमार दास
तो नाटा लिखि दियो
दिलीप कुमार
जहाँ दरकार हो तो पचारियो से बुझिकिन कहबो
पचार दियो तू से जहाँ कहबे यू कैन इनकॉर्पोरेट दैट इन द नेक्स्ट
हाँ नेक्स्ट वीक so we'll take up this matter. So what else is there in the Ajaita लिखी देबे the learning counsel for the appellant सेटा लिखी देबे they appear through virtual mode बोली जोड़ा लिखा है से order है ना and the advocate is also present had Mr. Mulia and counsel for the appellant in CRLA number so and so as well as for the content signals and data points number so and so and Mr. Tripathi and additional government advocate Mr. Mulia submitted a date chart along with a short note of argument which is taken on record. Put up this matter on 25th of June 2025 and it will be taken up at 2 p.m. and the learning counsel for the state shall ensure the appearance of the appellants through virtual mode and the sponsor this Mr. Das which remains present. देखा इच्छी जो order है ना okay so what else is there in the press admission call the matter you have to wait Mr. Jakrullah हाँ कौन है जी there is delay
302
there is no delay
ମୋର ପ୍ରଥମ ଦିନ କରିଦେଲେ ଆଜି ଲିମିଟେସନ ସହିତ ଦେଇଛନ୍ତି ଆଇଏଟା
no item number 2 तो CRLA number 546
there is no delay
the stamp reporter why have you filed the delay condonation application you are filing court today
ଏଇଟା ହଉଛି एडमिशन ପାଇଁ
हाँ ये एडमिशन पे थिला तो डिले तो नहीं अपन देखो CRLA नंबर आइटम नंबर 2 इसे 302 केस alright hard admit call for the trial court record interim application for bail and stay realization of fine to be considered after receipt of the trial court report deposition copy shall be supplied by the land council for the appellant and the land council for the state बाकी जो से ऑर्डर्स गुड़ा रही है नहीं आसो काली काल तो ना गुड़ा शुणा है ना ठीक है श्योर